A very good evening to all of y'all. First of all, thank you so much. Earlier, my lectures got rescheduled due to a family health emergency. Okay, so now in today's lecture, we will be covering all the important chapters and give you a tremendous boost. Okay, I would be trying to cover at least 50% of your syllabus. Okay, in this particular marathon. Now, when we start, I'll tell you what is the plan. We are immediately going to start. We are going to first start with the amendment sheet. Okay. And this amendment sheet, I will be sharing it in the WhatsApp group. So you all can get access to that as well. Okay. So the amendment sheets, I will just share it. Okay. Give me 1 minute. I will share it in the WhatsApp groups. Okay. So this is the full amendment sheet that I have prepared. Okay, directly you all can cover from here. 1 second. So first I will start with the amendments only. Okay, so now we begin with the ECIPL amendments. Amendment sheets I am sharing in the WhatsApp group. The WhatsApp group in if you're there in any of the WhatsApp groups, absolutely fine. I am going to cover this entire amendments in a span of 15 minutes. Okay, so I'm going to time myself so I can cover multiple chapters for you. All you need to do is sit with your book and pen and start knocking off chapters with me. Okay, till now if you have not liked the video, please go ahead and like the video and share it among your friends as well. And I want excitement in the chat box. Are we good to go? Yes or no? Everyone in the chat box, GTG, excited? Yes or no? So quickly I can begin with the amendments. Everyone, right? So let's begin. Okay, great, everyone. Good evening, Maha, Arun, great. Waiting for you all in the chat box. We're going to start and complete and knock off in the most heavy weighted chapter also. Okay, you are Shri, great. Let's begin. Okay, Kevin, great. Okay, let's begin. Hi. So in this video, I will be covering the amendments for your ECIPL for your June 2025 attempt. Now in the supplement sheet or the amendment sheet issued by ICSI, they had covered the amendments from earlier attempts also, which is already updated in our lectures and we've already covered it last time. Like for example, your FTP is exactly the same. Your ODI regulations, they have kept the same. So in this lecture, we will be covering the new ones which are applicable, which were not there in December 2024. Okay, so let's begin. The very first amendment is with respect to FEMA, Foreign Exchange Management Act, where they have introduced compounding proceedings rules 2004. And it's a supremely simple thing. Okay, so let's see. First, we have to write that the compounding regulations, okay, which has come, they have repealed the FEM compounding proceedings rules 2004. They have replaced the earlier, they have superseded the FEM compounding rules to 2000. So earlier in your modules, it is possible that you have the word compounding proceedings with respect to FEMA chapter. Your rules 2000, you will write that it has been superseded with rule number with rules 2004. Now what is compounding? Let me tell you in short. Okay, the meaning of the term compounding. So compounding is a voluntary admission of contravention, that yes, I have made a mistake. There is a voluntary admission of contravention of the act, that yes, by mistake I have missed filing certain things, or by mistake I have violated this section, I go to the regulators, I say that please take some charges and settle the matter. So in compounding, it's a voluntary process where the party can themselves, the violator himself will come forward and state that he is ready to pay some monetary penalty to settle the violation, and then no prosecution, no case will go against him. So in one line, what do you mean by the term compounding? Compounding is basically a settlement with authorities, okay, settlement that you have done on paying certain charges, on paying certain compounding charges. The authorities will not prosecute you, will not file a case against you. If case is filed, they will drop it. Clear? Now, earlier compounding application and the entire process was covered under Foreign Exchange Compounding Proceedings Rules 2000, and now it has been replaced by the 2024 regulation. Now, what does it talk about? Very simple thing. There is no complication. They have just divided the authorities. What they have said, that for section other than section 3A, so they have said that who will compound FEMA offenses, okay, FEMA matters. Who will compound? Who is the compounding authority? So in the 2024 regulation, they said that there will be two authorities. Which two, sir? So the first one is your RBI, Reserve Bank of India, will be your compounding authority for all matters other than section 3. So they will say except for section 3A, all other than section 3A, the RBI will authorize. So RBI will authorize all except section 3A violations. Sir, what is section 3A? Section 3A is about Hawala transactions. So Hawala transactions will be managed by the Enforcement Directorate. So for ED, Enforcement Directorate will deal with, okay, will compound section 3A violations. Section 3A violations. Clear? Okay. Now, if you know, so this is clear. This is the entire thing. This is RBI will deal with other than section 3A, and Enforcement Directorate will deal exclusively with section 3A matters, which are Hawala transactions. Now, if you know, if you've ever studied RBI, there are multiple levels of officers and multiple hierarchy in officers. So on basis of the amount that is coming in compounding, the compounding limit has been set up for each authority. Means the Assistant General Manager will compound up till 60 lakhs. Okay, so if any matter is, if we have done a violation and the compounding amount comes to 60 lakhs, up to 60 lakhs, then the assistant can do. But like that, it keeps going, and if it is a matter of more than 5 crores, then the Chief General Manager will compound. So this hierarchy I have given, these notes are available in my WhatsApp and Telegram groups. Now, similarly, Enforcement Directorate will settle matters with respect to Hawala transactions. And here also there are multiple, in ED office also there are multiple officers, the deputy, additional, etc. Depending on the compounding amount that is coming, the authority will have the power. So up to 5 lakhs, if the compounding is coming, then the deputy director will settle the matter. If it is 5 lakhs but less than 10 lakhs, then the additional director, and in the highest level, okay, will be to the special director and the legal advisor. Okay, so obviously you can't remember all the authorities, but at least you can write the provision that there have been the compounding limit. On basis of the compounding limit, the officers will be authorized to settle the matter. Okay, and you can give 1 2 examples. So this starts with 5 lakhs, this goes on with 60 lakhs. Okay, now moving forward, the procedure for compounding. Now it is very simple. Okay, now what is the procedure for compounding? So first thing, if you go to see, who will come forward to compound the matter? Will the authorities come, or the violator will come? think and tell me. Obviously, it is a voluntary process. You have to admit that you've done an offense. So first application will be sent to the authority, maybe RBI. RBI will examine the documents, assess whether the contravention can be compounded, and then determine how much money is to be paid. Okay. Scrutiny of the application will be given. Now, second, request for additional information. If the compounding authority feels that additional information should be brought, they can ask for it. Now, while deciding the compounding, following factors will be looked into. For example, if I have to decide what will be the compounding amount, how much we should allow to settle. So this is important. You can write this answer that depending on the gain, undue gain that you have got, loss that you have caused to another, the repeatedness of the offense, etc., and any other factors will be looked into before deciding how much compounding amount will be given. Okay. Now, under section 13 of FEMA Act, compounding amount may be up to 3 times of the sum involved in the contravention. So how much ever you have done a fraud of, that much, up till 3 times you might have to pay the charges. Okay. Now, issue of the compounding order. Now, very simple. First, what did we see? We saw the process, and process is very simple. I give you the application. The authority will look at the application. They will determine how big offense you have done, and they'll fix the compounding charge. Now comes to the other thing is issue of the compounding order. Now they are saying from the authority within how much time they should close the matter. So moment I receive the application, within a span of 180 days, the authority, the compounding authority, maybe it be RBI or ED, will close the matter. Opportunity being heard will be given. Okay. And if opportunity being heard is given and you can personally appear, you might not have to appear through a legal representative. If you are doing settlement, we're not punishing you. So you can come not personally and not through your legal representative. If you don't come, then authority will proceed ex parte on basis of whatever information they have. Okay. Contents of the order, they will tell you what violations you have done. Okay. And a copy of the order will be given and also published on RBI website. Okay. So if we go through again, very simple. What either this is all your entire thing and we are done. Okay. So what was it? It is basically your hierarchy. The offense, the compounding authority is divided. RBI and ED. RBI deals with all matters except section 3A, and ED deals with section 3A matters only. Authority, the applicant or the offender or the company will approach the company with a compounding application. The authority will review the application, ask for more information, look at the various factors, and then pass an order and then publish that order. After giving an opportunity being heard, we'll accept the application and then put it on the website also. That's it, and we are done with the particular amendment. Next, with respect to FEMA only, there is another very small thing, but I don't think it's very important. It is your Foreign Exchange Management Manner of Receipt and Payment Regulations 2003. So, Foreign Exchange Management Manner of Receipt and Payment Regulations 2003. First, understand what is this about, and then you will find it very easy. So here, think and tell me, whenever this is an international trade, okay, so money is coming in or it is going out in foreign exchange, right? Foreign exchange is happening. So we can say import export is happening, import export is happening. Okay. So now what will be the currency that will be traded? So what is the manner of receiving the payment? If I make an export, in what manner will I get the money? Will I get rupees? Will I get pound? What will I get? And if I have to make a payment, if I made an import, I have to make a payment. So the manner of receipt and payment has been given, and it's very simple that it is a foreign trade. So normally everything should come in foreign currency. Am I right? Yes or no? If I am making an export, ideally I am making an export to person in UAE, so then he will give me dirham. If I am exporting to someone in Europe, it will get in euro. If I am sending to Japan, I get Japanese yen. So here it is saying that by default rule is default rule is that you will get foreign currency. Simple, easy, done. And normally foreign currency, you think if I'm exporting into Thailand, am I allowed to get Thailand baht in India? So they say, listen, normally we don't allow any kind of currency, or maybe if someone has sold to Pakistan, do we accept Pakistani rupee? So the answer is RBI will tell you which all foreign currencies are allowed. Okay, so there are some universal foreign currencies, okay, which are accepted, like dollars, pound, euro, yen. So normally RBI issues a list saying that these are the acceptable foreign currencies in which you can trade. Random currency cannot come in. That's it. Now, what are they saying? That Asian countries, now two divisions that they have made, this is the base rule. It is understood, common sense only. You're exporting, you will get foreign currency, and normally foreign currency, not any foreign currency, only recognized foreign currency is allowed to come. So we will tell if you have baht, convert it into dollar and then get it into India. Now, with respect to Nepal and Bhutan, and with respect to some Asian Corporation Treaty, okay, Asian countries that are there, Asian countries, they are saying Nepal and Bhutan, we have a bilateral treaty. We already have a bilateral treaty with them. So therefore, money can come in rupees. It is fine. In Nepal, Nepal and Bhutan are part of India only. It is deemed to be a part of India for the purpose of FEMA, and that is why money can come in their rupees, and money can be exported in rupees also. So payment can be made in Indian rupees abroad, allowed in Nepal, Bhutan. They are part of India only. Okay, because they were a part of India, so then they are saying that rupee free trade is allowed. So very great thing has been allowed here. Obviously foreign currency you're dealing very good, but even rupees also allowed, buying selling in rupees, just like you would have done, because we are even the land barriers are we are connected through land barriers that are also open so many times. So we have open land barriers. Okay, so it is allowed. Now when it comes to Asian currencies, remember China, Japan, India, Singapore, we all had come and we will make our own Asian currency. This is mainly done to reduce the dependency on dollars. So we don't want USA to get too strong. So China, India, Japan, they said that we will make an Asian Corporation Treaty and we will say that we will trade in our own currency. So they said it is absolutely allowed here also. That's it. Done. Topic over. Done. So only to introduce these two things, they have brought this part. Okay. Now let's see and close it. Not too important. We can quickly move ahead. Okay. Now what is this? That the FEM, Foreign Exchange Management of Manner and Receipt of Regulations, saying that the receipt or making of payments by a person resident in India or outside India. So payment, how it will be made by me to abroad, or the foreigner to me, or me to foreigner. So they say one thing, that whatever you do, you cannot do it in cash. It will only be routed through authorized dealers of RBI. So obviously whichever currency it is, it has to be routed through a, so this is your first line, that it will be routed through only through authorized channels of RBI. Now quickly we can write and move ahead. Okay, if there is a trade transaction like import export, I just told you, if there is import export, if it is a import and export, so they are breaking it down into trade transaction and non-trade. Non-trade might be a tourist coming into India, or we are going abroad. So how will we deal? So first we talk of business transaction, then we talk of non-business transactions, okay, which I am not taking for commercial purpose to sell further. So payments for exports or import shall be governed. Now see, Nepal and Bhutan are allowed in Indian rupees. Clearly, okay, even for exports to Nepal, when we are exporting to Nepal, it is ideally India only. Foreign currency may be accepted for us, so it is good now if foreign currency is coming. If the central bank of, like how we have RBI, this is the central bank Central Bank of Nepal. So if they are allowing, then you can take foreign currency we are selling. So if a Indian exporter is there, he can get Indian rupees, or he can get foreign currency also if the central bank of that Nepal is allowing. Now with ACU members, sir, what is ACU? ACU is Asian Clearing Union. I told you we had made our own currency, etc. Is a regional payment arrangement for Asian countries only. Okay, so Singapore, Japan, China, they all are here. Okay, so to facilitate trade in local currencies, Asian currency, like how Europe has, if Germany is there, there is all these other countries, but Switzerland, but they still have euro. So what happened is, what is happening is they make one currency for their own continent only. So here we are also planning to do Asian currency we will make. So Asian Clearing Corporation is a regional payment mechanism which we are allowing now. Obviously US has come in and he has said that we will not allow this thing to come, be it like a trade war. But so the reason why we have brought this own currency of ours is to reduce our dependency or reduce the strengthening of dollars. For ACU members, okay, for Nepal and Bhutan, I told you already we have a bilateral treaty, so that is different. For other Asian countries, it must be made through the Asian Clearing Union mechanism, as RBI will specify. So those rules, etc., will be specified by RBI how it is to be made. Okay, if goods are shipped from a ACU country, but the supplier is from non-ACU, then the payment is outside the ACU mechanism, and then the normal as it would be to foreigners, that will apply. So here what are they saying, that if the goods are shipped from ACU country, okay, but so let's say this is the seller and the further raw material supplier is here, and here we have the buyer. So if both of all the parties are ACU mechanism, Asian, then only this Asian mechanism will apply. This as per RBI directions. That if all the parties are Asian, then only all this mechanism operates. But if anyone is non-ACU, maybe he is from USA, then we don't follow the ACU mechanism and rules. Simple. Okay. With other countries, payment may be made in Indian rupees or in foreign currency depending on the contractual obligation. So with other than Asian countries, we can make payment in Indian rupees or in foreign currency. Okay, why government has allowed Indian currency? It's fine, we can make Indian. We want foreign currency to come in, but going out, we don't want foreign currency to go out. So option has been given. If we are making a payment and the other guy is ready to accept rupees, well and good, otherwise we'll make obviously in foreign currency. That's it. In non-trade transaction. Now sir, what is non-trade? Non-business, tourist. So obviously with Nepal, Bhutan, in Indian rupees also you can do. Okay, so it does not involve exports. It might be medical treatment, we have gone, we are making a donation, we are doing personal remittance, we are going traveling there, so we can make expenses in Indian rupees. So just imagine, with Indian rupees, can I go in USA and spend Indian rupees? No, I need to convert. But in Nepal, Bhutan, I am allowed to spend Indian rupees. With other countries also, they are saying that payments may be made in Indian rupees. So we as Indians and Indian law, we are saying that payment wherever you go, if they are accepting Indian rupees, make it, or even foreign currency, obviously you will have to pay of that country. Now other way around, now when a foreigner visits foreign visitor in India, so when any current account transaction other than business, maybe he's personal, he's come for his own education purpose, then or he is come for traveling, okay, then between a resident Indian and a visiting non-resident must be settled only in Indian rupees. So when obviously when a foreigner visitor will come in India, he has to spend in Indian rupees. Simple little transactions and it is done. Clear? So we are done with the second one also, and it is pretty logical also, that Whenever you're making a payment, we will look at it as a business transaction, non-business. Essentially, the rules remain the same. Only in business, we will mention ACU members also. Okay. Now, we begin with the next amendment, which is about prohibition of Benami transactions. Here, section number 24. Section number 24. It is amended. Let's see what it is. So very simple, they talk what is a Benami transaction. So Benami transaction is a transaction in which the real owner, okay, the real owner name is not reflected on the property. The real owner holds the property through a fictitious name or through any other person. Means it's my house. I have paid the money. The person who pays the consideration, his name is not coming in the property papers. So that is called as a Benami transaction. Now what happens? Normally central government says that if it is a Benami transaction and you not disclose your source of income and it is for fraud, black money, etc., we will directly attach the property and that property will become of the central government. This becomes the central government becomes or confiscates the property, becomes owner. But obviously there will be a procedure that will be followed and that procedure is covered in section number 24. So section 24 says we will give a notice. The notice, so let's see. The notice will be replied. We will hear to your notice. After giving an opportunity being heard, we will try to first do a provisional attachment. A provisional attachment will be done. Inquiry will be done and then approving authority will tell whether you should extend the provisional attachment or no. And in the end, if you are found guilty, it will be confiscated. If you are not found guilty, the property will be released. Simple. So that is your section number 24, not too complicated. Section 24, Prohibition of Benami Property Transaction 1988, outlines a procedure to be followed by an initiating officer. The person who gives the notice, the person who initiates the case is called as the initiating officer. The initiating officer will do the investigation, like the officer, or you could say the investigating officer. He will start the case, collect the evidence, and then he will give it present before the adjudicating authority. The adjudicating authority is a real court. They pass the judgment. They give the judgment. And the initiating officer is nothing but an officer. He is a police officer kind of a person. Okay, so he is an investigation officer. Now let's see. So first, very simple, if the initiating officer, what is the first rule? That subsection 1, that if the initiating officer has reasons to believe that the Benamdar, that a property is Benami transaction or it is a Benami property, he will issue a notice. And he will issue a show cause notice as to why the property should not be confiscated by the central government. Now notice will be given even to the beneficial owner. So even the beneficial owner will be given, and even the person whose name is mentioned in the property papers, even he will be given. He is called as Benamdar. Benamdar is the person whose name is on the property. Beneficial owner is the real owner who has paid the consideration. So notice will be given to both the parties. They will get a time to respond. Okay, that submit your reply. Okay, within the certain period, but it shall not exceed 3 months from the date of the month on which the notice was issued. So reply time to respond is max 3 months. Max 3 months. Okay, 3 months reply is good enough time, 90 days. And now during that time, I told you that till the notice and everything is given, the person might try to sell it. So to ensure that he doesn't sell off the property, the initiating officer believes that there is a risk of alienation of the property, that he will try to sell off the property, he may provisionally attach the property. Okay, this can be done only with the prior approval of the approving authority and shall not exceed 4 months from the date of issue of the notice. So this provisional attachment can be max for 4 months, okay, with approval of approving authority. So there is another authority called as approving authority who will approve whether provisional attachment should be done or no. Then comes action after inquiry. So after that, after 4 months, action will be taken. Okay. If the property was already provisionally attached and you're found guilty, then obviously matter will be closed. The initiating officer may, with the approval of the approving authority, continue the provisional attachment until an order has been passed, okay, or revoke the order. So he will. So three officers are there here. Who? So just remember the flow, and then it's very simple. Okay. So there are three flows. One is initiating officer. Okay, he initiates the transaction. Second is the apart from the initiating officer, then comes the approving authority, who approves whether provisional attachment should be done, should be extended or no. And the final judgment will come by the adjudicating authority. That is the real court. So they give the final order. What do they do? Approving authority with respect to provisional attachment. Should we attach the property or no? And initiating officer starts or initiates the inquiry. Clear? Very simple. Okay. And section 55A, power to tender immunity from prosecution. So very simple, that a immunity can be granted. And immunity, what does it mean? That if a person has come and he has given full disclosure, okay, of what is a full transaction, etc., and how he was fooled into anything, if that is given and we find that this person is genuine, we will give him immunity. Now this is not a mandatory thing that we have to give a immunity. Immunity means a protection from prosecution, that you will not go in jail. So this is like someone can come forward and tell. So grant of immunity. The initiating officer may, with the approval of the competent authority, grant the immunity from prosecuting to the benamdar or any other person, excluding the beneficial owner, if such a full disclosure is made of the facts relating to the property. But it is not given to the beneficial owner. See, the real person who gave the money played the real game. So immunity is not given to him. He is given for benamdar, the person whose name is there. He said, I don't know only who put my name. Okay, so benamdar is the person whose name is put but doesn't own the property. He did not pay the consideration. Effect of granting the immunity on, you will get the immunity from all kind of prosecution penalties, etc. If you did anything wrong or concealed any fact, then it can be withdrawn, and if they have withdrawn, it will lead to reinitiation of the prosecution against you and liable to penalties as well. Okay. With this, we've also completed the your amendment with respect to your Benami transactions. Now we come to the most important amendment, which is your Competition Act 2002 amendment. Okay, so it is most important amendment. Sir, what it is? Very simple. The threshold on the section 5 and 6 have changed. So thresholds under section 5, which is combinations, has been changed or has been revised. So that we need to look. Concept remains the same. Let's see. Sir, what is section 5? So section 5 is about combinations. What is section 5 about? Combination. Sir, what is a combination? So a combinations are large M&As, mergers and amalgamations. So what happens? By law, that all these large combinations require to intimate CCI. They have to notify Competition Commission of India before beginning, because what happens, these are really two big companies, might cause a monopoly in the market. That is why they say that you need to notify the CCI. Now what is it? What is a combination? So this is the limit they have given. Okay, now this is the revised limit. Okay, this is the revised limit, new limit. Okay, very simple. The format remains the same. Let's see. So first pay attention what it is. We are talking about company A and company B. They both plan to merge. So that is called as a combination. They are combining together. So they become company AB. Normally government says that whichever company wants to merge, amalgamate, what do you let them do it. However, if it is a large merger, Pepsi and Coke, so they change the entire dynamics of the country, where it can, the entire combination can have an adverse effect on competition. They can kill the they can kill they can kill the competition. Okay, they can abuse their dominant position. So that is why they say that whenever big companies are merging, okay, you please come to us and take our approval. So you have to take approval of CCI. If certain asset turnover, asset thresholds of the combined entity. So we see the thresholds here. Thresholds of the combined entity we will see. If the assets cross the level, or the turnover of both the companies are exceeding the levels, and now they have given you even a third figure has also been added, which is called as deal value thresholds. Deal value. So if any of these three thresholds of the new entity is hit, then you have to take approval of CCI. So that means if you have exceeded the asset thresholds, or you have exceeded the turnover thresholds, or you have exceeded the deal value thresholds, okay, then you require approval of CCI. So if I am below the limit of asset threshold, or I am below the limit of turnover, or I am below the level of deal value, then I don't require approval of CCI. So let's see asset turnover, how to remember. Okay, so thresholds for filing notice. So just remember one start. Okay, just remember this. Now this is in India. So when all the parties are in India only. Okay, and this is India with Indian nexus, means worldwide with India. This. So this is maybe a foreign entities involved. Okay, this is an enterprise level, A plus B. Two companies are merging. In group level, more than two companies are merging. So we can have A, B plus C. Okay, where Vedanta Group is merging with Reliance Group, is merging with Tata Group. So when groups are involved, the second category will come. So this is the first category, and this is the second category, group level. Here also remember this figure. That's it. Okay, 10,000 crores. Above you remember 2,500 crores. That's it. Now remember, everything will get done. This is asset side, and this is the turnover base. So you just take this pen, do into 3. Here also you do into 3. Here also you do into 3. This side. Okay, here also you do into 3. So see, all the limits are hit. So 2,500 into 3, turnover becomes, so turnover is 3x. So if the assets are 1.25 billion, then this will be into 3. If you do, it is 3.75 billion. With at least, here they say that at least some component, if it is a foreign company also, there is a foreign element involved. So then they say at least this much should be in India. Combined is there, but however, some in India should be there. Now when you come from 2,500 and below you're going, you will do from here, you will do into 4. Okay, from here you will do into 4. Let's see. Into 4. Here if I do, see till here all these limits we got 7,500. Okay, and if you go down, you get into 4. Okay, so into 4. Similar, here into 3, and here when you do, it is into 4. Okay, so that's how you can remember. Let's see. So if we take this 2500 into 4, so you will get 10,000. Okay, so this is 10,000. Okay, now if you come here, 7,500 into 4, we'll get 30,000. We'll get 30,000. Okay, so if you just remember this figure, you can come on this figure, and then this side either you do or you do here. So one and the same thing. Okay, now again if you go to see 1.25 billion into 4, you get 5 billion. Okay, so if you take this figure 1.25 and you come here, you do into 4, so then you get 5 billion. Okay, so I think just the easier thing is just remember two figures and everything else can be fit. If I remember this figure and this figure, I'm done, I'm sorted. Okay, so 2000, just remember one thing completely and then you're sorted. So 1 point, what will you remember? You can remember this entire thing. Okay, to remember the easiest part. Okay, so only thing you'll remember is this much and this entire thing. Okay, once you do this, that side you will come to know, below you will come to know. If you come to know 10,000 here, then you know it's 30,000 there, and then 1.25 into you can take your calci, right? So into 4 you will get 5, and that side it is 15. That is done. Clear till here? Even from year to year you do 1.25 into 3, so 3.75. so from here also you will get. Concept clear? So two figures you have to remember, and it's pretty simple also. 2,500, 1.25 billion, and that's it. Everything else will be fit in. Now coming to de minimis exemption. Now mark this as important. Understand what it is. Till now we did the thresholds for combination, the new thresholds. Okay, 2,500 you have to remember, into 3, and below you go into 4. So you do into 3 and into 4, and then you fill your entire table. Now de minimis exemption, what does it mean? Pay attention. Now we saw that the assets, if it is 2,500 crores, okay, 2,500 crores, okay, the combined value, then what happens is it becomes a combination, and this side if you go, or so this is assets, and your turnover that time is into 3, so it is 7,500 crores. Just taking the first example to make you understand something. Now is this the threshold only for A, or it is thresholds only for B, or it is thresholds for AB, for the combined entity? So obviously it is for the combined entity. Now pay attention to this kind of thing. What is the logic of the government saying that, listen, it's a really big transaction, if something happens, then the entire market will change, you are going to change the entire dynamics. Now think about Reliance itself might have an assets of 2,500 crores. Reliance itself has a threshold or assets of 2,500 crores. So they are saying that if I merge with anyone, even with someone having a 1 crore valuation, even with this, their target company here is 1 crore. So it will become a combination now, because it becomes 2,500 and 1 crore assets. Okay, 2,501 crore. So law says, listen, there is a problem. So what we will say, if the target company is de minimis, is small, then exemption is given, no approval of CCI. So what is it? That if target company, okay, is not exceeding certain thresholds, okay, then no approval of CCI. No approval of CCI. So how small is the target company? They have given here. Okay, they have said that threshold for availing the exemption from getting approval of CCI. So if the target companies, okay, assets are not exceeding 4,500 crores or are less than or equal to 4,500 crores, then you are a small company, because major part is this, you are just 4,000 or 450 crores and turnover is, again you multiply. Always what we do, we multiply to go on the other side. What do we multiply? 450 into 3. Okay. 1350. Okay. So this should be 1350. Okay. So they have kept 1250. So just remember the threshold that they have given you. That for this 450 crores and 1250. This is the threshold that you will take. That if the target company is not exceeding this asset or this turnover threshold, then no approval of CCI. Acquirer might be too big and you are too small, then it is not something which is changing the market dynamics. Reliance acquiring any small company also should not come into taking approval from CCI. That is it. And the third new threshold that has come is the deal value thresholds. So it is the deal value thresholds. What does it talk about? That even if normally from many years they have the asset thresholds and the turnover thresholds. So even if asset or turnover is not exceeded as per section 5. So section 5 has given certain assets and turnover test. If that is not exceeded, maybe let's say it's a brand new company, it's a software company having no turnover and very little assets, but because of its potential, some investor is ready to invest, valuing your company, the entire value of your company exceeds 2,000 crores, then it requires approval of CCI. Sir, how it can exceed more than 2,000 crores when it doesn't have assets also, it doesn't have turnover also that much? So answer is, sometimes when we feel that some companies are operating at loss, but they can just blast, to another level. So some AI app is there and then an investor has come in, they say, okay fine, I see potential in it, though the assets and turnover is not being breached, the thresholds are not being breached, okay, where that 2,500 crores is not there, might be 1,000 crores, might be 1,500 crores, okay, but we feel that the money exchange is valuing a company of 2,000 crores or more, then based on the deal value, this is also a threshold and approval of CCI has to be taken. So pay attention that any deal in connection with any acquisition of control shares, voting rights, so investor is coming in, he's acquiring control shares, voting rights, etc. of an enterprise, merger or amalgamation exceeding, so the deal value is exceeding 2,000 crores, then it requires approval of CCI. So normally the traditional matrix which are there, assets, and this is not being looked into, we are simply looking at the deal value that is being exchanged. Simple. I think they can ask you an exam question on that. Okay. So that was the important thing about threshold change in section 5 and a introduction of deal value thresholds of 2,000 crores. So what they have given you, if it exceeds 2,000 crores, the deal value, then even if the asset and turnovers are not meeting the requirement under section 5, still approval of CCI is required. Now we see the next amendment in Consumer Protection Act 2019. One, they have given you the thresholds for the your jurisdiction, which is the same. Okay, in last attempt also it was the same, and now also it is the same. They have just repeated it, that in consumer courts we have certain multiple levels of courts. The lowest is district commission, the other one is state commission, and the third one is national commission. So district, state and national. So in district commission, they are saying where the value of the goods and services paid for the constituent does not exceed 50 lakhs. Then the matter will go to district commission. Means up till 50 lakhs, if the amount of the goods and service it is there, amount paid in the goods and services are up, let's say 5 lakh rupees, it will go to district. But if I say it is of 55 lakh rupees, then it cannot go to district. The district cannot take up a matter more than 50 lakh rupees. Then it will go to, if it exceeds 50 lakhs but not exceeds 2 crores, then it will go to state commission. But if it is a matter of 10 crores, then it has to be go to national commission. So this limit is same as earlier limit only, but you can just remember. So you can remember this threshold: 50 lakhs, 2 crores and greater than 2 crores. So just remember 50 lakhs and 2 crores. So it comes 0 to 50 is 1, okay, is 1, 50 to 2 crores is 1, and third is greater than 2 crores. Greater than 2 crores. So from this is district commission, from here to here is the state commission, and from here it is a national commission. In your consumer protection, they have added few case laws. Okay, they have added very few basic case laws which is there, which I have kept it. Okay, so consumer protection case laws has been added. So let's do that. I believe one of this can come. You will get this entire notes in my WhatsApp groups. You can go join it and take it. Now, first I'll just tell you the crux. What was the main thing in the case? That Consumer Commission issued a arrest warrant for non-compliance of his orders to a director who was a previous director. At the date of issue of the notice, he was not the director of the company. So it was held that even if he is not the director right now, but during it is a violation done during his tenure, he can be given a notice. So he can be given even if at the date of the complaint or the date of the order he is not the director anymore. So basically, if I was holding position in a company as a director, now I'm not, but for my earlier matters, notice can come to me. Similarly, whether a transaction is commercial purpose depends on the dominant intent, not the legal form of the status buyer. Okay. So here what happens, if we want to look at the, see, tell me one thing, commercial purpose, can it come under consumer protection? Yes or no? Can commercial purpose come under this? Can commercial purpose come under consumer? Can you be counted as a consumer if it is not for your livelihood? For livelihood, yes, but if it is not for livelihood, then it cannot come. So the question came up that there was a director, company purchased the flat for the director's residence. So whether it is a commercial or residential, commercial or non-commercial, company purchased the flat for director's residence. The seller claimed that the buyer, he was not under consumer because it is a commercial purpose. It was held that the dominant purpose was residential use and not to further sell it. Therefore, it was allowed. So, director for whom the company has bought the flat, he is a consumer. The next one is Alpha versus Magnum International Trading. The Consumer Protection Act must be interpreted liberally and not be defeated by technicality. See, Consumer Act is a welfare legislation, and welfare legislation, as per our interpretation of statutes, always means that benefit will be given, extreme technicalities will not be asked, procedural fluctuation can be given, procedural flaws can be ignored, so that more and more benefit can be given. Then Secretary versus Mahindra Lame, eligibility for Consumer Commission appointment must be reasonable and constitutionally valid. So who will sit in the consumer forums? So the eligibility criteria was made and experience criteria was arbitrarily made. So the government struck down that you cannot make appointment in the consumer commissions, okay, or randomly. It has to have some logical intention. See, it's a government organization. When you're appointing a government organization, there has to be a criteria why you're appointing a person. Random, arbitrary qualification and experience, if we are making as a rule, it is unjustifiable and void. Joint application by a few consumers is not a representative suit unless the procedural requirements of CPC are followed. Now remember one thing, that if a representative suit means many people coming together with common interest, but representative suit is not given in Consumer Act, it is given in CPC Act, Civil Procedure Code. So they are saying that if people are filing joint complaint by few consumers, it is not a representative suit unless you are following the CPC, because main representative suits are under civil procedures, and if you are not following the procedure, then it not a benefits of representative suit will not be given. Okay, then they said that 50% deposit when you are going to appeal is mandatory. Okay, it pre-deposit is mandatory. Okay, it has to be given. When I am going in appeal, I have to deposit 50% of the amount determined by the lower authority. Then comes very simple, in Shobha versus MK Shobha developers, a recognized consumer association has a right to file a complaint on behalf of its consumers. So very simple, that a recognized consumer association will obviously have a right to file the complaints on behalf of the consumer. So this is like a NGO. This might be an NGO who wants to file some complaint on behalf of consumers. It is permitted. With this, we have completed the entire amendments for your June 2025 attempt. Rest all you can study from our dream batch. Everything is in place. Thank you. Okay, clear till here? Now, okay, now we will be starting with the other thing. Now we will be starting with your most important chapter. I believe all of us know in your okay, let's see. If we go here, okay, can anyone tell me which is the most heavy weighted chapter, most asked chapter in EBCL? Everyone in the chat box, let's see if you all know what it is. So from all of this, which is the chapter which has the highest weightage? From your part A, okay, part A is your 60 marks. Part A is 60 marks. And approximately, in the earlier old syllabus, for many years, they had kept this thing. Competition Act. They had kept Competition Act for 20 to 25 marks. Okay, so you can expect a very at least 20 marks coming from Competition Act alone. So just imagine, this is 60 and they've added one heavyweight chapter out here. So I feel 15 marks, so they will ask only. So first my job is to complete competition law, all the aspects, so that nothing is left out, and your 20 marks or 15 marks, whatever it is in your pocket. Clear? So we will start with the Competition Act 2002. Okay, we will start with Competition Act and complete the entire Competition Act. Clear? Very good. Arun, Yuvashri, great. Okay, so we'll just take a 5-minute breather. 5-minute breather. Till that I will go fast. Okay, so I want you all to just go through the entire chapter once. Okay, before I start with the chapter. So what's the thing? 6. So we will start in 5 minutes. Okay, so just revise and close it. And I will be starting with competition at 15-20 marks. I'll complete and give it to you, and I'll try in 1 hour I'll complete it. Am I audible and visible, everyone? Can you all please confirm in the chat box? So give me 1 hour, I will complete the full chapter. Okay. So good to go. Can we begin? Okay. Okay. So now I need a confirmation. Now am I audible and visible? Okay. So now am I audible and visible quickly? Okay, great. Okay, great. Chalo, let's begin. So again, students, this is a fast-paced revision where I will cover every topic but in a fast-paced manner. Okay, in case if you all want, you all can get the access to the dream badge and complete it in depth. Let's begin. So just quickly, am I audible and visible in the chat box? Yes or no? Okay. Now, am I audible, visible? Great. Let's begin. Hi. So, just a second. Hi. So we start with Competition Act 2002. Now let's understand the entire history of the Competition Act 2002. How did it come into force? So first you have to remember two articles. Okay. So article number 38 and 39. The article number 38-39 said that it is a duty of the state to ensure that goods and services are available at fair prices. So the Constitution of India said that it is a duty of the state to ensure that goods and services are available at a reasonable price. So the government started thinking that when are the goods and services not available at fair prices? So government is thinking that when do goods and services are not available at fair prices? So then they thought that whenever there is a monopoly, if I am the sole seller, then I will not sell it at fair prices. So then the government said, okay, fine. So we will enact something called as MRTP Act. We will restrict monopolies. Monopolies Restrictive Trade Practices Act 1969 was passed. Why it was passed? Government said during monopoly, nobody sells at low price. We will restrict monopoly. So MRTP Act, okay, 1969 was passed. Then came liberalization, privatization and globalization, where they said that why are you restricting monopoly? Why are you going in a negative concept? Negative concept. Restricting someone is a negative concept. So why don't you instead do something which is more globally recognized? So they say that we want that goods and services should be available at reasonable prices. So they said yes, what the world does, they have introduced something called as Competition Act. Competition Act, okay, and India brought this in 2002 on the recommendation of SVS Raghavan. So under the chairmanship of SVS Raghavan. What did Mr. SVS Raghavan say? That internationally people don't restrict monopolies, they don't break a monopoly, they encourage competition. Moment competition comes, the prices of the goods and services will come down because everybody will start selling at competitive prices. So then they brought in, they shifted the entire focus, okay, from curbing competition to from restricting monopoly to encouraging competition. Now it all started even in Sachar committee. Earlier time, if I go to see, Sachar committee appointed by the government in 1977 recommended significant changes to curb unfair trader practice. So this was just changes were brought in. Act was not yet repealed. They added part B called as unfair trade practice. So we are looking at the history how Competition Act came. First MRTP was there, then in Sachar committee they amended MRTP Act and brought in one part B, which is unfair trade practice. Then came our main player, which is called as SVS Raghavan. SVS Raghavan, on his basis the entire act was repealed and we have Competition Act 2002 today. Concept clear, the background history right from the constitutional to the entire this is clear, right from constitution, that article 38, 39, then brought in MRTP, and then now we see Competition Act 2002. Now we're going to look at the objectives of Competition Act 2002. Okay, now this I want every single one of you all to note it down, write it down and quote it in your exam, this case law, because it gives you the objective of MRTP Act, the objective of Competition Act 2002. So in CCI versus Steel Authority of India. So what is the name of the case law? The name of the case law is Competition Commission of India versus Steel Authority of India. This you will write there. In that, the Supreme Court has said that this is the object of the act. So the object of the Competition Act is to obviously encourage competition. Once you encourage competition, you eliminate any practice which has a, you will write this word AAC. Through the entire chapter, I will be taking you through this word which is called as AAC. What is AAC? Appreciable adverse effect. Appreciable means possible adverse effect. So technical words also I'll keep telling you. You need to note it down through the entire chapter and you will be good to build your answer. So a possible adverse effect is there. Okay. So whenever the act finds that there is an AAC, appreciable adverse effect on competition, it will take action. Okay, they will protect the consumer and ensure free trade. And obviously one more objective of the act is to establish CCI. So this I believe all of y'all will write it in your exam. The CCI versus SAIL, which gave the object of the act, and object of the act you can write 1, 2, 3, 4, 5 points. Clear? Moving forward, if you just have to understand the definition of the term competition. What do you mean by the term competition? So I would say a competition is how do you, in English, how do I say competition? So first of all, Competition Act is not defined under the act. But in English, if I ask you, so competition means rivalry. What does it mean? Rivalry. Okay, rivalry. Now rivalry to get attention or to attract customers. Rivalry to attract customers is called as competition. Moving forward, why do we need competition in the market? Now, why there should be competition in the market? So just take the names of all these places, which all these things which is there, and then I'll tell you all one common benefits we will write. What is the need for competition as per the World Bank, as per the OECD, Asian Development Bank, okay, Asian Development Bank. So we'll write 3 authorities I've told you. What is the need for competition as per World Bank, as per OECD, as per Asian Development Bank? Now I'm thinking logically, what is the benefit of competition? So first of all, here we have all the benefits together. Okay. Further, you just write the names and then you write. Okay. All the benefits I'll tell together only. So in Excel Crop Care versus CCI, they are also telling the benefits of competition. Now we are seeing the benefits. All together you will write your benefits of having competition in the market. Why we should have competition? First of all, it will ensure that everybody is more effective, cost sensitive. They will all try to minimize the cost. So there is a economic efficiency, less wastage. Okay, there will be lesser wastage, because everybody will say that this guy is also coming, how is he selling at less price? Then second comes is economic growth. Now why there is economic growth? Obviously there is similar lines only. People will allocate their money in better resources. They'll do lesser wastage. What is the benefit of competition? Obviously it is benefit for customers. Customers will get cheap. Jio came, he gave free, everybody enjoyed. Okay. Then came, it has a positive impact on economy. So it has been found out that wherever any market where there is competition, the market is more healthy. The people work towards efficiency, and there is more growth of the entire economy. Okay, so this is all that you will write. Now, in one more line you can write, whenever there is a competition, people start benchmarking, which increases productivity. So one more point you can write, that whenever there is competition, so competition means you always keep looking at what the other guy is doing, what all other good things he is doing, and try to incorporate. So that is called as benchmarking, is learning from competitors, is keeping your competitors' performance as a threshold and try to exceed it every time. So competition facilitates benchmarking, exposing our weaknesses, their strength, and overall leading to innovation and cost efficiency. Simple. Now, competition policy versus law. What is the difference between competition policy versus law? Which is a wider concept? See, when I say policy, policy is a wider concept. Whereas competition law, competition law is basically like Competition Act 2002. Now, when I say policy, policy could mean anything under the sun which encourages competition. For example, easier licensing. So that also encourages competition. It's not a law. There's no section for make a easy license, make the process online. That was not given. Competition Act 2002 is a subset. So in the policy, one of the thing is make good laws. The other thing is make the procedural delays less corruption, less everything. So policy is a much wider concept, okay, rather than actual laws and sections. So the laws and sections are a part of policy, but policy can include other things also. Okay, anything to increase a particular competition, even if the government comes out and says that we will give subsidy. So that is a encouraging competition, right? It's not a section, it's not a law, it's not an act, but it is a policy. Okay, that is there. Now we start with the Competition Act. So now we have finished the background. Okay, we finished the complete background of how this Competition Act 2002 came into force. What is competition? Why it should be there? We learned the case law also, CCI versus SAIL, which we will be quoting in the exam. Now we're looking at the other thing. The other thing are the sections. The entire act, okay, is important, but I will tell you the important sections till where you should know, and it's very simple sequence. Section 3 is anti-competitive agreements, 4 is dominant position, 5 and 6 is combination, and 7 is setting up of CCI. So anti-competitive agreement, no person should enter into any agreement which is against having a AAC on competition, appreciable adverse effect. No person should misuse his strong position in the market. Large mergers and amalgamations are called as combination. They require approval of CCI. Okay, and CCI. Now, what is CCI is given under section number 7. So, central government has set up CCI where any competition related disputes will be taken up before CCI. So, just like SEBI is for securities law, competition related disputes will be dealt with CCI, Competition Commission of India. We'll look at each section wise and complete it. Okay, so first we start with the definitions. In the definitions, not all the definitions are important, but one definition particularly is important, which is called as cartels. Sir, what are cartels? Now, section 2 subsection C. So if you look at the picture, what do you see? What do you see here? So if imagine they want us to compete, but we don't want to compete. What we are doing? We are saying all of us, let's come together and rise our prices. So the sellers, producers, manufacturers, if collectively everybody rise the prices, that is wrong because consumers will be at loss. Or other way around, we say all of us will do short production. We'll create artificial shortage. So this is called as a cartel. A cartel is basically a agreement among the people who should compete. They all of them are coming together and saying we will not compete. We say what nonsense. So cartels is section 2C. For C only remember. What it is, let's see. So cartels is an association of producers, sellers, distributors, all of them, traders coming together and having an agreement. And what is the agreement? That we will limit the control, production, supply, distribution of goods or service. So it is an association of all these sellers, distributors, traders, and they are having an agreement. An agreement is to control the production or pricing or the anything with respect to the goods and service. So cartels are prohibited under the Competition Act 2002. Now there are two kinds of cartel. Now pay attention to this. We are looking at the types of cartels. So there are types of cartels. Now there can be a import cartel or export cartel. So domestic cartel is something which is happening in India, whereas international cartel is where more than one country is involved. So first remember, international cartel is a cartel where more than one country is involved. So there must be an import or export. Common sense. So you tell me which one will be allowed. Which one government will say, okay, fine, this kind of cartel is allowed. Let's see. An import cartel, you tell me whether that will be allowed. What is happening here? Importers, all Indian importers are importing the goods and saying that we will increase the price and sell it in India. All of us. You think that will be allowed? Because in India, Indians will be given goods at high price. So import cartels are not allowed. Because importers are coming together and deciding the selling price in India. That's not allowed. But export cartel is where exporters are coming together and they'll say we will charge a high price from foreigners. So government is saying export cartels are allowed because you are charging foreigners high value and then we'll get good foreign currency. So import cartels not allowed, export cartels are permitted. Clear? Then you tell me one thing. Can cartels in today's time be done? Or I will tell all the classes or all of us will increase the prices. Is that possible? Or a business owner who is dealing in clothes, he will say all of us, all the traders. They say cartels are only possible if the sellers are few. Okay, there is very difficult new people to come in, high entry barriers. Everyone is dealing in the same goods. Okay, then only cartels are possible. Otherwise, it is very difficult to have a agreement among everyone and all of us. I convince them to increase the prices. So it is only possible where there are few competitors, new entry, high entry barriers. Everyone's dealing with the same product. Okay, and consumers will have to only buy from me. So there is a high dependence of consumers on that product, and there is a history of our collusion. So in the past also we've kept doing. So all these things show that cartelization can be done. Okay. So then we are not done with cartels. There is something called as hub and spokes cartel. Now pay attention to what is hub and spokes cartel. When we read by cartels, they had told what all did they say in cartels? Who are covered in cartels? So cartels is basically an agreement. So we are looking at cartels. Cartels are basically an agreement between sellers, traders, producers, distributors, etc. Okay. So cartels is an agreement between sellers, distributors, etc. Now what happens? Imagine there is an association like a NGO. This NGO is neither a seller, nor a trader, nor a producer, nor a distributor. They are simply advice they give. They are a strategic unit. What are they? They are a strategic unit where there are multiple traders who are members of it. So there are sellers 1, seller 2, seller 3, seller 3. So let's say there are 3 sellers only in the market, okay, and all the 3 are listening to this. They all come and meet at one association, one NGO. So what is happening? This NGO says, let's do one thing, let's manipulate the price, let's all increase. Now question comes that can we take action against the association? So the association will say, I'm not a seller or a trader or a producer, how you can put me under cartel? So then the government said, let's make a hub and spokes cartel where this will be treated as a hub. So hub is basically a strategic advisory unit where maybe other people are members, and these are treated as spokes. Spokes are these spikes. So if there is a hub and spoke cartelization happening, if there is a hub which is controlling all these spokes, then when we find that there is a case of cartelization, even the hub can be held liable. This is what they have said. Very simple little concept. So let's read. Who is the hub? A hub is a central coordinating hub which is orchestrating, which is actually doing the anti-competitive agreements, and it is controlling companies. They are called as the spokes, and because of their entire orchestrator or their entire strategy, what is happening? AAC is happening. We are having appreciable adverse effect on competition. Then action can be held liable on the hub and spokes as well. This is all that you need to write. Okay. Now we come to the next thing. Okay, one simple little point. What do you mean by the term enterprise? So enterprise here means a business. Enterprise means what? A business, na? Which is, and in business what you do? Either goods or service. Even government department is included. So government also does business, na? So if the post office, etc., they are also covered in enterprise. But it does not include wherever the government is doing sovereign functions. So sovereign functions could be defense. I cannot defense when government is giving a service of defending you, of protecting you. That is not a competition act will not apply there. So competition act only applies when there is a goods and service given where private sector is also competing. Where government is the only player in the market, when it is a sovereign supreme for protection of the, like another example of a sovereign function could be the judiciary. The judiciary can only pass judgments, etc. So that is not an enterprise logically. Persons include natural as well as artificial persons. Then we come acquisition, means acquiring certain shares, voting rights, etc. Agreement could be an agreement. If I'm saying there was an agreement between the sellers, it could be written or it could be oral agreement also. Clear? Simple points. Then we always have the same definition as consumer for under Consumer Protection Act. So what is consumer? Consumer means a person who is buying goods or service for consideration. Okay, and for personal use. Okay, does not include commercial purpose unless it is for livelihood. That is all. Done. Now, with this we are done with the important definitions given under section 2. Now we are looking section 3. Very important. So section 3 are talking of anti-competitive agreement. Sir, what is anti-competitive agreement? Any agreement which has a AAC, appreciable adverse effect on competition, is called as anti-competitive agreement. In simple words, any agreement which affects competition, which harasses competition, which kills the competition, is anti-competitive. So you think we can enter into an agreement to kill competition? Can Reliance enter into an agreement to kill the competition? Answer is no. Section number 3. Now we are starting with section number 3 onwards. And section number 3, subsection 1, 2, 3, 4, all I will ask you. And all I will make you by heart. Section number 3, subsection 1 says that no enterprise shall enter into anti-competitive agreement. So no enterprise shall enter into anti-competitive agreement. Subsection 2 says if they do, it is void. So if any agreement is entered in contravention with the provision, any anti-competitive agreement is done, then it is void. Now subsection 3 and 4 is important. Okay. Now pay attention to this. Subsection 3 and 4. Now pay attention to what we are doing. You can take a screenshot of it, okay, if you want. Now what are they saying? First, what are we doing? We are doing section 3, which talks about anti-competitive agreement. Any competition, any agreement which is against competition is void. Subsection 3, subsection 3 and 3 subsection 4. 3 subsection 3 talks about horizontal agreement. Sir, what is a horizontal agreement? Horizontal agreement is an agreement between direct competitors. For example, Pepsi, Coke. So if direct competitors are entering into an agreement not to compete, it is a horizontal agreement. Direct competitors are coming together and deciding to manipulate or do something, either to do artificial shortage or to fix the price. Let's fix high. All of us are, you and me are the only competitors. Let's both of us increase the price, or allocate the market that you sell in this area, I will sell in this area. And fourth is bid rigging. If the competitors in a bidding process, so this you remember, section 3, subsection 3, subclause 4, bid rigging. We'll come to what is bid rigging. It is basically manipulating the bidding process where the bidders itself decide not to compete against each other. So this is all competitors, bidders are all competitors. So bid rigging is also anti-competitive. It's a type of horizontal agreement. So beautifully explained, understood. Vertical agreement is between persons who are not competitors. They are not competitors. Okay, they are instead business partners. They are business partners and operating at a different stage in the business. Sir, what does it mean? So raw material supplier and manufacturer, they are both supporting each other and operating at a different stage. Manufacturer and distributor, so they operate in the same supply chain of that product. They are all in the same supply chain at a different stage. Okay, the distributor, retailer, etc. Okay, the wholesaler, they all are here. Now, agreement between these people could be of different kinds, each of which we will see. Clear? Tie-in agreements, exclusive supply, exclusive distribution, refusal to deal, resale price, maintenance. Now, always remember that presumption that if you have done horizontal agreement, it will be presumed that it already has adverse effect on competition. Horizontal agreement, government will be very, very angry. Don't enter into horizontal agreement. Vertical agreements, when you are entering, government will not presume that it is having adverse effect on competition. They will look into whether it is genuine or not. Sometimes there might be refusal to deal, but as a part of franchise agreement, McDonald's can tell its franchisee that don't deal with anyone else. So sometimes vertical agreements held between business partners can be allowed depending on facts of case, but horizontal are deemed to be wrong. So horizontal, because direct competitors are having into agreement, it is illogical. Okay, so it seems that there is something fishy. But in between business partners, you might have. So law does not presume that you have appreciable adverse effect in vertical agreements. Sir, examples, very simple. As I told you, fixing now between competitors, if I fix the price, or I limit the control production, or I distribute the location. I say you operate in Gujarat, I'll operate in Maharashtra. We will not compete against each other. Market allocation. So that is also there. And last one is bid rigging. Bid rigging means what? manipulating the bidding process. So section 3 subsection 3D is bid rigging. Sir, what is bid rigging? If the bidder, so in one line if I have to tell you, bid rigging is a process of manipulating the bidding process. So how will you manipulate? Where the bidders enter into agreement to not compete. They will do intentional manipulation. They can predetermine that you take this product at this price, I will take it at this price. They fix it up. Okay. So agreement persons who should be competing, okay, so they are entering into agreement. So obviously it is a kind of horizontal agreement and it is deemed to be anti-competitive. And who is at loss in bidding? It is the owner of the goods. If my goods are being sold, I don't get the real price. So bid rigging affects competition because the real price of the goods will not be known. Okay. So how can you come to know that someone is doing bid rigging? If they are submitting identical bids, already there is an agreement that who will give the lowest bids, not to compete against each other, not to allow new people inside, designating winners in advance. So these are all signs of bid rigging. Now when I see vertical agreement, now vertical agreement is by business partners who are operating at a different stage in the production or distribution chain. Okay, so there are different types. Tie-in agreement. Okay, so sir, what is a tie-in agreement? That if you purchase one product, you, as a condition of purchasing one product, you have to purchase the other product also. Sir, how it is possible? So there was a very classic case of against Google, and there was one guy also, his name, let's see if we have his name, you should know his name also. Case law you should quote in the exam. Javed. So I want all of you all to write this. Case law. Okay. Is Urfi Javed? No, not Urfi Javed. What is her name? Umar Javed. Maybe a brother or something. Umar Javed versus Google. Now what had happened is Google's policy was that you have to mandatorily buy Google. You will, if you are taking a handset, mobile phone, install already few of my products will be installed, like Google Maps, Google Photos, all this will come in. So he said that it is wrong now. Why force these products already inside and then charge it from the customer? You are purposely forcing that if you want to sell this, then you have to give the other products also. So customers, and he won the case. Okay, Google was wrong. Now moving forward, so tie-in agreement, as a condition to buy one, you have to buy the other also. Now exclusive dealing agreement. Now what is a dealing agreement? Here they have said that, and always remember here it is goods or service. So tie-in agreement could be for a service also. Okay, where I say that if you are joining my gym, you have to mandatorily buy my personal training services also. So it's a goods and services, which was there after the amendment. They have introduced every goods and service. Fine. So it's not only restricted to goods, but if you do this similar thing in services also, then also it is anti-competitive. Exclusive dealing agreement means you're restricting the purchaser or the seller, okay, from acquiring goods other than other than me, you cannot deal with anyone else. Okay. Exclusive distribution agreement is basically allocating the market. This is your market, this is my market. Now this is happening between business partners. In horizontal agreements, you are doing between competitors. Refusal to deal is basically I refuse to deal with anyone. Okay, I will tell that you cannot you cannot deal with anyone, or limiting their right to deal with others can be treated as refusal to deal. Resale price maintenance. So whenever you set the resale price, and I am giving it to you and you will further give it at this price, or you will not sell it at below this price, is also kind of a resale price maintenance. It is not allowed. Now coming to section 3 subsection 4 also we did. Okay, 3 subsection 3 we did, 3 subsection 4 we did. Now 3 subsection 5 is about intellectual property rights. Now pay attention to this: intellectual property rights and export of goods. Now the section 3 restriction. Section 3 deals with what? Anti-competitive agreement. Very, very important, can come in your exam. Anti-competitive agreements. Can you enter into anti-competitive agreement? Yes or no? Quickly. Can you enter into anti-competitive agreement? Yes or no? Okay. So basically, anti-competitive agreement is, you can do if it is export. I already told you, export cartels are allowed. So if a person is trying to export from India, then he can do anti-competitive. He can try to kill the competition abroad. It is absolutely fine. Second is, nothing in this section 3 should be deemed that you don't have a right to protect your intellectual property. Safeguarding of intellectual, so nothing should be there that nothing in section 3 is preventing a person from protecting his intellectual property if it is there. For example, if I am telling you that you cannot deal with anyone so that my intellectual property is protected, that you will not disclose my thing to anyone else, so then it is to protect my intellectual property, it is absolutely allowed. So section 3.5 is like an exception when you can enter into anti-competitive agreement. The right of a person to restrain another person or to impose any reasonable conditions. Why are they doing it? For protecting any intellectual property like patents, copyright, trademark, etc. is allowed. Any person trying to export the goods, that is also allowed. Okay. Now, what is deemed to be anti-competitive agreement? If anywhere we are trying to limit, we are trying to have a, you have to write the word AAC. If any person is having an agreement to have an appreciable adverse effect on competition, it is anti-competitive. So anti-competitive includes but are not limited to. So there are multiple things that how you can do. We saw all these examples, all of them you can write. All we did na, anti-competitive agreement in section 3.3 and 3.4, all you have to write. Horizontal, vertical. Okay. Now we come to abuse of dominant position. Okay, what do you mean by the term abuse of dominant position? So first thing is, abuse of dominant position means, abuse word means misuse and dominant means position of strength. So if a person has a dominant position, a position of strength, means he can operate individually. He can operate in Reliance Industries can operate independently in the market. They don't care of anyone else, and they can affect competition as they want. So this is called as dominant position. If you misuse your dominant position where you can operate independently and affect others, then action or punishment is there. So it is prohibited to abuse your dominant position. So in section number 4, they have given a plain vanilla thing that no person shall enter into a abuse his dominant position. It shall be abusive if you have tried to put a condition or discriminatory unfair condition or a unfair price, or you're trying to limit the production. So whenever you try to control or limit the price or the production, it is deemed to be abusive. Then we came to section number 5 and 6. Okay, now we are seeing section number 5 and 6. Sir, what is section 5 and 6? We just did the new thresholds for section 5 and 6. So I taught you all that whenever combinations are entered, they need an approval of CCI. Sir, what is a combination? Large mergers and amalgamation are called as combinations. So just remember this figure, 2500. So you remember 2500, and you will remember this 1.25 billion. Now you just do into 3 year, that's it. You will get these figures, and when you come here from year to year when you go, just do into 4. Okay, here also it is the same thing. So if the combined value, if two companies are merging, okay, A and B are merging, here what is happening, more than two companies are merging, so there is A plus B plus C, or maybe a group being merged, then the limits are here for group. For individual levels, here it is given. If it is all Indian transaction, domestic transaction only, no foreign companies involved, then this is the limit. A category you look. If there is a foreign company involved, then you look at B thresholds. Okay, so this is given 2,500 your turnover. So if either the assets or the turnover limit has been breached, then you have to take approval of CCI. And deal value, D minus, that if the target company's thresholds are this much, then approval is not needed. So if the thresholds are below 450 crores assets and turnover is below is less than or equal to 1250 crores, then approval of CCI is not needed when the target company is small. We have done this. And the third category is deal value thresholds, that even if the assets and liabilities are not there, but a deal has been struck which is more than 2000 crores, then approval of CCI is needed. Okay, now we come to section number 6. Approval of CCI is needed. So section number 6 says that if it is a combination above, you cannot enter into the combination without consent of CCI. If you do, it is void. So subsection 1 is saying that no person, no company shall enter into a combination, okay, without the consent of CCI. If they do, it is void. Subsection 2 says that when you are entering into a combination, into a merger, you have to give them information and you shall give them a notice to CCI in the prescribed form. That is, in 150 days you have to wait, compulsory wait. I'll come to it. So notice has to be given. Okay, so first thing is, if you enter into a combination without the consent of CCI, it is void. You have to mandatorily give a notice. Third, such intimation should be after. Now, when I should inform CCI? When I have thought of doing a merger, or there has to be some concrete steps that has been taken where we can say that company is very close to a merger, then we will tell them. So either the BOD has approved the M&A or any other document which has been signed for acquisition, like a offer letter or a SPA agreement, share purchase agreement, etc. has been entered. So any concrete steps has been taken. After that, then you have to inform the CCI and take their approval. Now, section 2 we did. Now section 2A, compulsory wait period. Once I give the notice to CCI, I have to compulsorily wait for 150 days. Earlier this limit was more. Now it is 150 days. I have to give a notice and wait. Now I'm waiting. Fine, I'm waiting. If 150 days I don't get a reply, it is deemed approval. But before 150 days, if they approve it, then I can directly move ahead. So unless they have approved earlier, the companies have to mandatorily wait for 150 days unless approved earlier. That's it. Okay. Now all this is green channels, etc. is what we will come. You don't need to remember all this exactly. Okay. One, you have to remember that section 6 subsection 9 is exemption to specified institutions. Now understand that whenever certain institutions are there, financial institutions who always give loan to companies. So if a PFI, public financial institution, FII, a bank, a venture capital fund, they normally give loans to companies. They have entered into an investment or a loan agreement. And now let's say the company cannot pay the loan. Pursuant to that, they are acquiring the shares of this company pursuant to a loan or an investment agreement. Will we say it is a combination? They got some shares, etc. They say no, This is not a combination purpose. Combination when two companies are merging for business purpose. Here what is happening, you could default the loan. So we bought your shares, transfer of shares is there. We have got control, maybe two companies, we got 50% of your shares, but this is not a M&A. So they say that all these institutions, when they acquire the shares pursuant to a loan agreement, that is exempt from CCI approval. So in all of this, you don't require approval of CCI. Okay. Now, even implementation of open offer. So can a acquirer give a open offer to the target company? Does he need to take CCI approval? Yes or no? Situational question can come. So an acquirer is there, he gives an open offer to the target company that I want to buy your shares. Okay. Is approval of CCI needed? So the answer is it is not needed, but you cannot exercise any ownership rights. So if you want to exercise voting rights or ownership rights, any of that, get dividend, so then you need to take approval of CCI. So acquirer can give open offer but cannot exercise any rights till CCI approval. So obviously CCI approval is needed. Okay. Implement allows transaction to proceed if the acquirer adheres to the regulation, refrains from exercising ownership right. So he has to adhere. So he has to give a notice to CCI, and he should not exercise any ownership rights till commission approves the said acquisition. Okay. Then we move ahead to the next thing, which is section number 7. Sir, what is section number 7? Section number 7 is basically your Competition Commission of India, CCI. So CCI is the organ, is the authority that will determine disputes when it comes to competition related disputes. Now, central government has set up the CCI. They've given you the composition. I'll tell you when it is important. What is important? Chairperson will be there. Terms of their office. They will take oath. Post-term employment. Now imagine if someone is working in CCI, chairperson or member. If someone is working in CCI as a chairperson or a member for a period of 2 years from the date on which he ceases to hold an office, shall not accept any employment in which he was a party before the commission or any person who appears before the commission. Very simple, except if it is a government organization. That if I am the chairperson of CCI, after I get retired, post-retirement or post my employment, can I go and work in a company before whom they had before me who had appeared? So let's say if Reliance Industries had appeared before me, I passed a favorable order in their favor. Now when I retired, they gave me a job inside that company. So it creates a weakness on the part of the it might look biased. So they have said just to protect the sanctity of the post government, like how judges cannot join any political party. Similarly, a chairperson for a period of 2 years from the date when he ceases to hold the office shall not accept any job from any company, okay, who has appeared before him. Finish. Except if it is a government company. Now we go into the duties of the commission. Very, very simple. What is the job of CCI? So the job of CCI is to fulfill all the objects of the act: eliminate adverse effect, promote competition, protect investors, ensure free trade. So this is the object of act. Okay, that is what is important. So this is the powers. Now we come to inquiry into certain agreements and dominant position. Now we are looking at inquiry, how process will be done. Now pay attention to this, how they have done that. Okay, 4 times. Now let me explain. Okay, so first thing is section number 3 and 4. which is about anti-competitive agreements and abuse of dominant position, and section 5 and 6. Clear? Now for this they talk about investigation process, how the investigation will go on. Here also they will talk about investigation. Then they will say who is appointed. So the Director General will be appointed. All the process for all this is the same. So 2-3 times they will tell you process for this, and separately then again they will tell you process for this, whereas it is the same only. First, Director General initiates, he makes a prima facie opinion whether he should investigate or no. Okay, whether a default has happened on the complaint, he will look. Second, he will give a summons, or we can call it as a opportunity of being heard. So he will tell that we got his complaint. They will issue a show cause notice, hear all the parties, and then pass a order. That's it. So this will be there, and in the orders they will look at various factors. Now factors also they have given 4 times. They have given you for each one 1, 2, 3, 4 times factors they will look. Like if I want to see what all factors will determine something wrong is happening, we will see all this. Okay, so factors they give you 4 times. Factors are 4 times, but it's the same thing only. When there's an appreciable adverse effect, section 19 subsection 3. When there is a dominant position, factors have been given 19 subsection 4. Okay, for geographical market and geographical product. So for product they've given you in 9.7 and 9.6. okay, so we'll see. So just give you a background that now we'll be starting about inquiry. Now how does inquiry start? Someone must have complained or suo moto, 2 things. So the commission may inquire into an alleged complaint. So someone must have complained basis of an information, or some government must have done. Now this is important, just note it down. That newly there. So I'll just tell you what is important. Rest the flow is very simple. Limitation period for filing cases. The commission shall not entertain any information, any complaint, unless it is filed within 3 years from the date of the cause of action as arose. So the limitation period for consumer for competition matters is 3 years. Very, very, very important. Very, very, very important. That the if the cause of action arose now, if competition was breached now, within 3 years I have to reach CCI, otherwise ECIPL will not entertain the matter. Now I told you factors, so they will look at various factors such as how was the competition. So basically factors mean the study. They will study everything, the barriers, who are the competitors, how did this, what was the how did it benefit or harm the customer. So all these factors or surrounding circumstances will be studied. 4 times they will give you. Okay, for dominant position separate factors have been given, but same points it will be there. How we will study the consumers, we will study the product, we will study the market, we'll study the dominant position, we'll study the agreement type, we'll look at the cost to the society, benefit to the society, etc. Okay, now relevant market means where the competition has been affected. So what do you mean by the term relevant market? So relevant market is that market where competition is affected. For example, if I tell you that in Delhi XYZ market competition bid rigging has happened, so I'll find out that relevant market is the area where competition has been done. So imagine if there is a fight, so you'll ask now where did the fight happen, where is the jury? So accordingly we will do the inquiry whether it is a product market, one product all over India has been affected, or it is a geographical area where only in that area problem is there, rest all the areas are fine, or it is a mix of both. So relevant market could be a product market, or geographical market, or both. Okay, so all these factors again and again I told you will study the consumers, the products, the enterprise, the agreement, the benefits caused, the profit margin, all this entry barriers. So just make one answer and then write it in all factors. Okay, now we can go further. Okay, so we are almost done with the chapter. Few important parts further will come. Okay, let's see. Okay. Now we come again, same thing, like how they are told inquiry. Now they are saying inquiring into two things. Okay, the procedure for inquiry, section 3 and subsection 4. So section 26 outlines the procedure for inquiry with respect to these two things. Matter will be the same. The Director General will have to first make a prima facie opinion that whether wrong has happened or no. If it is not there, no prima facie case, the matter will be closed. If we find that the prima facie case is there, he will submit his report. He will ask the particular parties to give a objection or opportunity being heard, and after that he will prepare his own report and then pass the order. Simple, just keep it simple. Okay. Now orders that can be passed. Now if you see what all orders can be passed, simple. Either they will tell you don't do, close, allowed, modify. So three main orders type can be given. Okay, either do, don't do, or modify. So, and if they have done something wrong, they will tell you to rectify the particular defaults. Now same points have been done. It's just a statement of objections, procedure for investigation now into combination. The process is the same, exactly the same. Okay. Now just one thing is, one more point that they've added, that prima facie opinion should be made within 30 days. So initially, as I told you, limitation period has been added. Within 3 years you have to approach CCI, and CCI will inform their the Director General will form their opinion, prima facie opinion, within a span of 30 days. Okay, same process you can write, which I have told you. And as I told you, section number 31, you can write the orders that can be passed. Either they approve the combination, they tell that you disapprove it, or tell you that you can operate after modification. Now very, very, very important. Okay, very, very, very important is extraterritorial jurisdiction of the commission. What does it say? That extraterritorial means beyond India. So does the CCI have powers beyond India? Answer is yes. If any agreement, any party, any matter, any thing is happening outside India, but it is having an appreciable adverse effect in India, then the CCI will jurisdiction is extended even outside India. So it says that if any appreciable adverse effect is being caused by an agreement which is entered outside India, by a party is outside India, by a dominant position outside India, or any other matter which is happening outside India, but its effect is having adverse effect on competition in India, CCI can investigate the matter. Simple. Now just like a court, right? CCI is a court. It will have even the Director General is a authority, right? So they will all follow principles of natural justice or civil procedure code. In the court has the power to examine witnesses, pass interim orders, okay, pass final orders, call anyone on oath, etc. Now when the parties ask you to come, now section number 35 important from CS point of view, company secretary point of view, that who can appear before the CCI? So obviously complainant will appear, defendant will appear, the Director General will appear. So all the parties will come, complainant, defendant, Director General, and they can be represented through all the professionals. They may either appear in person or through any of the professionals like CA, CS, CMA, legal practitioners. Obviously parties hire lawyers and they will come, lawyers, company secretary, and come. Okay. As I told you, they have a power to make their own procedure, means they will follow principles of natural justice, and they have powers that of a civil court for summoning evidence, interim orders, etc. Okay, now this is a very interesting thing. I don't very simple, that if monetary penalty has been put on someone and that person is not paying, so money will be recovered from them. So if someone is we have put a fine and that person is not paying, then we can recover that fine as an income tax officer would have recovered. Okay, and income tax act schedule 2 of the income tax act, where it is written the procedure of recovery, how an income tax officer will do, that same procedure can be followed, and the term, instead of income tax, it will be treated as penalty. Just we'll change the words so that it can be applied. Okay, and instead of assessee, it will come as the accused. So the commission is of the opinion that is recover, they may even approach income tax authority for recovery. The person on whom the penalty is imposed shall be deemed to be the assessee. Simple. You can, just like an office, your CCI officer will have all the power that of a income tax officer for recovery, as an income tax officer would have recovered tax. This guy will recover the dues, and the procedure is given under schedule of Income Tax Act. Okay, duties of the Director General, section number 41. Very simple. What is the duties of the Director General? Investigate. He will be having the same powers that of a civil court and will be guided by principles of natural justice. And every company should provide all the information to the Director General and give him all assistance to the Director General. Now there are 3 things which are there, which is very, very simple. Section number 48, 48A, B and C. Now 48 applies to a company undergoing an investigation. So let's say if a company is undergoing an investigation, they can apply for settlement. Settlement is like compounding. They will pay the penalty and settle it. So section 48 is and this entire thing applies to a company who is undergoing investigation. They can say, please take the money and close the matter, settle the matter. So under section 48A, any company can approach the authorities and settle this case. Now while doing that, they can also give some commitment, some assurances that, listen, I did this mistake, I ensure that in future I will do these measures to rectify my mistake. And if the companies fail on doing paying the settlement amount or meeting any of the commitments, then action can be taken against them. Okay, so very simple. What is it? What it is, that settlement, the Competition Amendment Act 2023 introduced section 48A. A company, enterprise against whom an inquiry is initiated, okay, for an alleged contravention, can apply for the settlement before the CCI. Okay, so you pay the amount and close the matter. He will make an application. It will be evaluated. Government will not blindly accept it. They will, give an opportunity. They will, for their inputs, they can accept or reject. And then once they have accepted it, then the amount that he will pay will go to Consolidated Fund of India. And once you have settled it through settlement, then no appeal will lie. So these points you can write. It's an easy flow that you apply, they will study it and they might ask you to modify, and once they accept it, you cannot go in appeal and the money will go in Consolidated Fund of India. Similarly, a commitment can also be given by the company to settle it. They might also say that, listen, in future I will be good. A voluntary offer by the so that their application gets accepted for settlement, to address the alleged competition that they have done. They will give a certain commitments. Now they have not gone into depth. They will say again similar point, that they will look at the commitment, study, evaluate, either accept, not accept. If you have done it, then you cannot go in appeal. And lastly, if any of the violations is done of section 48A or 48B, then the order stands revoked and you will be liable to pay legal cost. And not only that, even the case will get restored again. Okay. Now we come to section number 49. Section 49 talks about competition advocacy. What is competition advocacy? That in India, who do you think will have the best knowledge about competition law? It will be CCI, because they are dealing with competition related matters day to day. So whenever the government is making laws with respect to competition, they can approach the CCI for recommendation. So according to the competition advocacy, to which the CCI can give recommendation to the central government. So the government may, while making policies, can make a reference to CCI. CCI has to give their opinion within 60 days. Now obviously it's just the opinion, so it is not binding on the government to listen to their opinion. Okay, and the commission is responsible for promoting advocacy, raising awareness, and training on competition related issues. Which is general stuff that central government, the government can approach CCI for advice. Obviously it's an advice, so it is not binding. Simple, done. This is competition advocacy. Now appellate authorities, very 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 important. Section 53. Okay, 53AB. This is the procedure. Please remember this, that if a person is aggrieved from the decision of CCI, they will go appeal to NCLAT. First it was CAT, Competition Appellate Tribunal, but that has been revoked or repealed, and now we have CAT in NCLAT. Okay, within 60 days from the order of CCI. If you're unhappy with NCLAT, then you can go in appeal to Supreme Court within 60 days. Now they've given you penalty. Normally penalty is not important, but here you have to read the penalty that is there. At least few of the important penalties you can remember. Okay. And that is it. We've completed the entire chapter. Thank you. Okay. So full 25 marker chapter I have completed. Okay. So that is it. Okay. So now again, if someone was asking that should they leave any chapter, FTP, I have covered a fast track revision in my dream batch. Go ahead, do it. Dream batch links are given in the WhatsApp group or Telegram group. So it gives you access. In that I have covered not only the detailed lecture but even a fast track revision. Okay. Now I will start with my next chapter. Okay, where the amendment has also come is your. So we begin with the next chapter. Till now, if you not liked the video, please like the video, at least this much. And if you not shared it with your friends, please share it in any of your WhatsApp group. So small little humble little request. Okay. Now we're going to start with this one. The prohibition of Benami property. Okay. Let's see. So we're going to start with prohibition of Benami property. Okay. Okay. So simple, we'll just take a 10-minute break as we normally do, and then we will come back and knock off the chapter. Okay, so we take a 10 minutes break. Till then, you can revise this entire chapter if you want. Okay, 10 minutes break, and then we come and complete it in one go. Okay. Hi guys, am I audible to you all? Quickly in the chat box, so we can start and complete. Am I audible, everyone? Okay. Where can we get the JT scanners? The JT scanners are available on the website under the free study material section. Okay, you can please go ahead and get it. Chalo, are we good to go, everybody? GTG in the chat box. I'll complete the full chapter for you. GTG in the chat box. I'll complete the full chapter for you. Okay, great, great. Yuvashri, great. What about others? Show me energy so that I can complete multiple chapters for you. So imagine in one day if I complete 6-7 major chapters. Good to go. Let's start. And complete it with me. Later nobody watches. Okay, better to sit now only and complete everything. Okay, just stay with me. I'll pull off and complete everything for you. Hi. So we start with our Prohibition of Benami Transactions Act 1988. Now the very first thing, let's understand the meaning of the term Benami. So Benam comes from a Persian word which means without a name. Normally, let me explain you with the help of a transaction. Now, Benami property is where the beneficial owner, okay. So let's say the buyer is there, the normal transaction. This is a normal transaction, okay. This is not a Benami transaction. This is a normal transaction. You pay the money and the property comes in your name. That's a normal transaction. But this is where a Benami transaction will look like. A Benami transaction is where okay. So in Benami transaction, what is happening is there is a person who is selling the property. So this is fine. He's selling the property, and there is a person who is buying the property. He is paying the consideration. The beneficial owner pays the consideration, but he says, don't put the property in my name. Put the property in name of another person called as Benamdar. Okay, so they say, why you don't want to? No, I don't want to disclose my source of income, that it is in my name. So I will just pay the money, but the property will come in someone else's name. So Benami transaction is a transaction where the consideration is paid by someone which is called as the beneficial owner, but the name of the property is not shown of the beneficial owner. Instead, it is shown of another person called as a Benamdar. This person could be another person, could be a fictitious person, could be a fake person, could be another agent just to disguise and hide his own originality. So obviously this kind of transactions are not permitted under law, and we have Prohibition of Benami Transactions Act. So let's understand the meaning of the term Benami. So Benami is a transaction where the identity of the real owner is called as the beneficial owner, is hidden, okay, and someone else's property, which else's name, which is called as a Benamdar. Benamdar is a person whose name is coming on record, but he has not paid the money for it. So money is paid by beneficial owner, and the consideration is paid by beneficial owner, and the property is showing the name of someone else. So this is like a illegal transaction. It is called as Benami transactions. Okay, let's start with the act. So to prohibit such kind of transactions, okay, government has made something called as a Prohibition of Benami transaction. So today if I tell you, can I pay the money and put someone else's name in it? Answer, it is illegal. Imagine I am buying a house, I pay the money and I put someone else's name. So that is illegal. Only in some cases we will see when it is allowed. Maybe it is a minor child, that is a different that permission is given. So we will see normally Benami transactions to hide the real owner details is illegal. Initially, the Benami Transaction Act had only 8 sections, and now after the amendment in 2016, Benami transactions has Prohibition of Benami Transaction Act has 72 sections. So we are seeing the sections, all the 72 sections here. From here, from this entire act, I want you to know the main sections, okay, which is your chapter number 2. In the exam, I want you to quote chapter 2, section 3 to 6. Your full chapter is contained here, the most important thing. And the main logic and the main consequences, the main concept is fit into 3 to 6. So few sections, chapter 2, section 3 to 6 we will learn. Let's see. So first, very simple. What is a Benami property? A property which is subject to the Benami transaction is called as Benami property. We'll come to the direct definition. The most important definition which you should know under the Act. Section 2 subsection 9. It defines what is a Benami transaction. Now, if I ask you, now I've told you the concept in general words, in basic words, in plain language, I've told you what is meaning of Benami transaction. Money is paid by someone, ownership is shown of someone else. That's a Benami transaction. But as per the Act, section 2 subsection 9, I want you to quote in the exam no matter if they ask you or no. If the topic comes, you have to quote that Benami transaction as defined under section 2 subsection 9. Now what it is, let's see. They give you in few parts. A transaction A, all of this is Benami transactions. B, a fictitious name, owner is not aware, and beneficial, owner not traceable. These 4 categories are treated as Benami transactions. Let's see. Section 2 subsection 9 defines what is a Benami transaction. It says it is a transaction where the beneficial owner pays the money and the name is there of the Benamdar. So Benamdar name is coming and the money is paid by the beneficial owner. That is a transaction. But it doesn't include. So some exceptions are there. Some exception that these are not Benami transactions. So first thing is, as I told you, minor. Okay, for your spouse or child if you're buying, and the source of income is disclosed. So it is told that I am paying the money from my salary and I am putting it in the name of my child. Allowed. In my wife's name, allowed. Joint owners. So joint owners are also allowed because obviously I pay the money and my name is coming, but major consideration is by someone else. Since both the names are reflected, it is allowed. His name is coming. So he's a joint owner. So obviously it's not a Benami transaction. HUF. Normally in a HUF, or the Karta is the owner, but it is possible that the money he has not paid. Okay. So HUF, Karta is the owner of the property, but obviously he has not paid the full money. So that is also allowed. And one FP. What is FP? Let's see. Fiduciary capacity. Okay. Fiduciary capacity, etc. For example, when you have done trust, okay. So in trust, what happens? Ratan Tata, he puts the name of the property in the name of the trustees. So in fiduciary capacity, they are holding. So all this is allowed. Then all these ones are Benami transaction. So a transaction where someone is paying the money and name is showing of someone else, except these 4. Fictitious name. So if in the name of the in the name of the property papers, it is coming Amar Akbar Anthony. They say, what, one person? Not this person is only not in existence. Third, the owner is not aware. The driver, someone is saying that a politician's driver's name is there and he is the owner of the house. The driver is saying, I don't know only that any such property is in my name. So such property will be shown as a Benami transaction. And fourth is it is not everybody ran away. So it is none of them are traceable. So let's see. What is a Benami transaction? So a transaction where the consideration is paid by another person and property is in the name of another person. Okay, but it does not include. So it is exceptions are there which shall not be treated as Benami transaction. HUF, Karta is holding for the benefit, he has not paid the money, allowed. Fiduciary capacity, trustee, executor of a will, partner, director, depository, all these are holding in the trust for someone else. Spouse or child, if the source of income is known, and joint properties, brothers, sisters, etc. are allowed as long as the source of income is disclosed. Then comes three simple transactions. Fictitious name, a transaction carried out in a fictitious name is a Benami transaction. Owner is not aware only of the transaction, denies the ownership, and where the person providing the consideration, that is the beneficial owner, is not traceable. You gave the money and you ran away. So it seems like a case of beneficial Benami transaction. Now they've given an example what is not Benami transaction. Now pay attention. One more is there, which is very simple. It is from section 53A of the TOPA Act. So section 53, what does it say? A builder gives it in the name of the owner. So builder gives the ownership, money might come later, registration, formalities, some things are left, that is not a Benami transaction. Does not include where possession is given. So they are saying that, listen, you gave the possession, ownership you transferred, money has not come. So they say, it is over a period of time it will be given. Okay. So for example, if a builder is there, Godrej just put it in your name, the property. Consideration will come future, registration will come in future. So that is also not a Benami transaction till everything is disclosed. Consideration is paid, okay, or is payable, but the person who has granted the possession thereof continues to hold the property. So consideration of such property has been provided by the person to whom possession has been allowed. So money has been given by the buyer, but ownership is still with the builder. Why? Because stamp duty registration is pending. Clear? So if any such thing is there, it is allowed. It's not a Benami transaction. Now, Benamdar. Who's a Benamdar? Whose name is put? Maybe a real person or a fictitious person whose name is coming in the Benami property, and who includes a person who has lent his own name. Beneficial owner is the one who is actually paid the money, who is entitled to the property. Now we come to the core sections. The core sections, which is the most important, chapter 2. What does it say? That first of all they are saying Benami transactions are prohibited. Okay. Second, they are saying that prohibition to recover the Benami transaction. So the beneficial owner, the real owner, cannot recover the property from the Benamdar. So beneficial owner is there. Okay, beneficial owner who paid the consideration. Now he cannot recover the property from the Benamdar. Instead, the Benamdar will have to give it to the central government. Okay, this property will only be confiscated. Now, property held Benami is liable to confiscation. I told you it will go directly to the central government. So it cannot be retransferred, and prohibition on retransfer of by the Benamdar. Now, so he also cannot recover by filing any case on this guy. Neither can he transfer it. Retransfer. So prohibition is on both. So if imagine there is a beneficial owner and there is a Benamdar. Okay, Benamdar. So he cannot sue him. So the beneficial owner cannot sue him to recover the property. Sue to recover. Neither can he, nor can he retransfer the property. Retransfer the property back to the beneficial owner. So then what will happen to this property? It will go to the central government. This is the entire act. This is the main provisions of the act. Let's see. Let's read and finish it off. Okay. Section 3. It's a penal provision on whom? That no person shall enter into a Benami transaction, and penalty has been given. Okay. So you can read up the penalty. Now, section 3 is saying don't do it. Now they are putting penalty on the real owner. On the real owner, that the real owner cannot file any suit nor he has any defense. So no suit action or to enforce any right against those whose name is held. So you cannot file, the beneficial owner cannot file any case on the Benamdar to recover the property, and he has no defense to defend his Benami property. Means the property is gone. To whom it is gone, sir? To whom is the property gone? It will be liable for confiscated under section 5 by the central government. The central government will confiscate it. Then comes section number 6. So earlier was prohibition on, section 4 was prohibition on the real owner. He cannot recover the property, he cannot file any case also. Section 6 is a prohibition on the Benamdar. The Benamdar also should not try to give it, he should directly give it to the central government. So section 3 says that the Benamdar shall not retransfer the Benami property held by him to the beneficial owner. Don't give it to the beneficial owner, give it to it. If you do it also, it is null and void. Okay. Now comes authorities and jurisdiction. So very simple here. It's a process how it will go. So it is a process. It's very simple, very simple process. Okay. So first what will happen? The initiating officer will feel that this property is Benami property. He will issue notice. He will issue notice to parties. A show cause notice will be given. A show cause notice will tell us why we should not attach it, and within so much time you come and approve. Second, we feel that now the initiating officer feels that now that I've given a notice, he will try to sell off the property, run away out of India. So he will do a provisional attachment. What he will do? A provisional attachment, so that you don't try to alienate the property, sell off the property. Then for this you will have to, in order to do a provisional attachment, you have to take approval of the approving authority, and the matter will go on before court, and the adjudicating authority will decide the matter. They will decide the matter. Clear? Now they might also appoint an administrator. Sir, what is an administrator? Administrator is to sell the property. Now what will the government do of the property? The government will appoint an administrator to look after the property, get the money from the property, sell the property, etc. So the administrator is like a liquidator. He is like a liquidator or the property manager appointed by the court. Okay, and all this is they can follow the procedure of civil procedure code. In addition, the officers under the act, under the Benami Property Act, can contact other officers also, can take assistance of various authorities. They can call up income tax authority, help me, custom authority, help me, narcotic substance, help me. Why? Because maybe we must have found that illegal money has come from XYZ sources, and with that this property is being bought. So we will tap RBI, SEBI, police, FEMA authorities. Okay, all the authorities can be tapped. Now comes chapter number 4, which talks about attachment, adjudication and confiscation. Very simple. Section number 24. That, as I told you, I have explained the process already. Show cause notice will be given. Provisional attachment can be done. Now how will the notice be given? Manner of notice. So obviously they will give you a notice, could be a summons. Obviously they will give it in writing. It will be delivered to you or to your home, delivered to your residence, or if it is a company, then it will be given to the registered office. The adjudicating authority will pass the order, take the property, okay, and appoint a manager, as I told, administrator, and take possession of the property. Let's see. That notice and attachment of the property. Think the flow is very simple, and this we have done also here. Okay, the section number 24. Procedure to be followed by the initiating officer. So first he will issue a show cause notice. He will issue a show cause notice to, if he has reasons to believe that it is a Benami property, he will issue it. He will issue even to the beneficial owner if he has identified that this guy has paid the money but his name is not put, and tell him to give his source of income, etc. He will give them a time to respond, max 3 months. Within 3 months you have to respond. He can do a provisional attachment if there is a risk of alienation. If there is a risk of selling of the property, they will attach the property. Okay. Action will be taken within 4 months from the date of issue of the notice. Okay. That is there. Approving authority will approve whether provisional attachment should be done, kept or no. And in the end, the adjudicating authority will pass the final order. Then comes manner of service of the notice. Very simple. It's like issued like how a summons of the court is issued. If it is a individual, it will be given to the individual. If it is a firm, it can be given to the partners. HUF, it will be given to the karta. If it is a company, it will be given to the public, to the officer, etc. Now, adjudication of Benami property. What is adjudication? I told you it is a final order. Adjudicating authority, before giving an order, will give you opportunity being heard to the following persons. So following person will be told that okay, come and explain your case. So who they will tell, which are the parties? Benamdar, beneficial owner, any person who is saying that he is the owner of the property, and a bank if they are also involved in giving the loan on that property. Okay. So the bank, so notice will be given by the court to the following people: Benamdar, beneficial owner, banking company if a loan is involved, and any person who is trying to claim to be the owner of the property. Okay, and then this is just a simple flow. After the entire flow, opportunity being heard, etc., confiscation will be done. Okay, now one very important where they can ask you a situational question is, what if there is the Benamdar, okay, Benamdar. This is the beneficial owner, okay, and this is a third party innocent buyer. Now pay attention to this, okay. They can ask you as a situational question. What happens is the Benamdar, okay, what he does, he sells property to innocent third party. Now the adjudicating authority, the court, will declare this transaction void, or they will say that this transaction is legal, allowed or not allowed. Transaction whether Benamdar quickly went and sold a property to an innocent third person, will the adjudicating authority declare this transaction valid or invalid quickly? So they will declare it valid, because why should innocent third party be put to loss? So the adjudicating authority will catch hold of the Benamdar and try to recover the money from the Benamdar. That's it. They will not declare it, because then the chain will keep going on. We can't run after everyone. We will directly catch the beneficial owner and the Benamdar. That's it. If it is sold to third party for consideration, the transaction is valid. The Benamdar will have to give the money received under this transaction. Okay, so this is where they have written. Market is important. That the provision shall not apply to of taking away from a person who has acquired by a person who has acquired the property for adequate consideration prior to the notice of this Benami transactions, etc. Okay, property, they can appoint a administrator to manage the property, sell the property like a liquidator, etc. As I told you, liquidator disposes of the property. Possession will be taken by the administrator of the property, and in order to take the possession, he can also take police assistance. Okay, if someone is not giving. Now we talk to the appellate authorities. So first is initiating officer. If you are unhappy with the decision of the initiating officer, you can go in appeal to the appellate tribunal. If you are unhappy with the decision of the appellate tribunal, you will go in appeal to the High Court within 60 days. So here the time frame is given. Okay, you will have to follow the procedure laid down under the CPC 1908 and guided by principles of natural justice. So from High Court, they have given you 60 days that you can note down. Okay, and the government, central government, may, with the consultation of the Chief Justice of the High Court, designate one or more of the Sessions Court to be a special court to try such matters. For example, if someone is going to ask that, listen, consumer matters, where you'll go, so you'll say na consumer court. For Benami transactions, where which court to go? So central government will, through a notification, tell that this Sessions Court will be the court for taking up Benami matters, and then they can try the court. Then they've given you the offences, penalties. You can't remember all, but at least remember this one. Penalty under the Benami transactions. Just mark this as important. All the penalties we can't remember. At least this we can remember. That for if you're guilty of Benami transaction, then a fine up to 25% of the fair market value, and minimum 1 year imprisonment up to 7 years imprisonment. And second, if you give false information, up to 10% fine will be up to 10% of the market value of the goods, and imprisonment will be given minimum 6 months and up to 5 years. So take a screenshot, note it down, at least write this in your examination. Okay, that is it. We have completed the entire chapter. Thank you. Clear till here? Yes or no, everyone? I want everyone in the chat box. Is this chapter clear for you all? Yes or no? Waiting for you all to give me a thumbs up. Yes, I'm covering everything, including whatever will come in past exam questions. Okay, great. All clear. Jansi, Arun, crystal clear. Yuvashri, great. Let's go to the next chapter, knock it off. Just looking at which chapter should I take and finish. Okay, which chapter should I take and finish? Should I go for this? FCRA Act technical. Okay. Okay, so one more chapter we'll be completing, which is called as your FCRA Act 2010. Okay, so now I'm going to cover this FCRA Act 2010. Clear till here? Everyone, before we start, please like the video, very small request, and one more small request, share it in your study circle groups. Okay, that is it. So we take a 5-minute break. We come back and we complete this entire chapter. Clear till here? Everyone, yes or no? I'll complete the full chapter, including all the past exam questions. I just need a confirmation from you all. Yes, great. So all of you all have liked the video, great. So 5-10 minutes you can revise this chapter. You can go through the JT past exam questions, whatever you want. In the next 5-10 minutes, I'll start and complete the chapter. Okay. Okay, so we'll be starting with your Foreign Contribution Regulation Act 2010. I quickly want in the WhatsApp, a message whether I'm audible and visible and we good to go or not. Here, can we begin? GTG in the chat box quickly. Okay, great. Jansi, great. What about others? So give me 15 minutes, 20 minutes. I will cover your full chapter for you, including everything in the this. Okay, so just a little bit of excitement you show, so it gives me also more pleasure. Be a little more participated by typing stuff. Okay, so it feels good. Arun, Yuvashri, Shakti, Jasi, great to have all of you all. Let's begin. Hi, so we'll be starting with a chapter called as Foreign Contribution Regulation Act. Let's understand what does this chapter talk about. It talks about a foreign donation. It talks about a foreign donations. So whenever a donation is coming from foreign, okay, so it's coming from a foreign source. So foreign source. This chapter applies when money in the form of donation is coming from abroad. Okay, it could be of two kinds. One, it could either be a foreign contribution or it could be a foreign hospitality. See, foreign contribution is about receiving donation in the form of goods, and foreign hospitality is basically receiving donations in the form of service. So whenever we receive donations from abroad, okay, so let's say there is a donations from abroad from foreign source. So when I say foreign source, foreign government, foreign company, foreigner basically giving a donation in India, that time we feel that this kind of donation could have a security issues, that why is someone giving donation in India. That is why the government of India, specifically Home Affairs. So this entire chapter comes under Ministry of Home Affairs. They feel that to protect the sovereignty and integrity of India, that someone is donating into India just to see that it is not something wrong, they are not trying to manipulate the government, etc. So then they regulate these donations, and in some matters, if they want to donate to a judge, they want to donate to a media house, then certain kind of donations are prohibited. If you want to give it for a meritorious student, etc., it will be allowed. So this is the entire chapter. In the chapter, they talk about these donations coming from foreign source are regulated and some are prohibited. Okay. So the object of the act is to regulate, control and prohibit what? Foreign contribution, that is goods, and foreign hospitality, that is service. Okay. This is all preventing anything which may have a detrimental interest to the country. And this entire law comes normally, all these comes under Ministry of Corporate Affairs, Ministry of Finance. This is one of the first chapters which says that this chapter is coming under Ministry of Home Affairs. Okay. So now when we see the sections also, we are mainly concerned with chapter number 2. That is foreign regulation of foreign contribution and foreign hospitality. Sir, what is foreign contribution? It is goods. So donation coming in the form of goods, and hospitality means donations coming in the form of a service. So we will see. Now let's understand the meaning of the term foreign contribution. Foreign contribution, I told, it is basically a foreign donation of goods. And remember the word ACS. What is the tagline that you'll remember? That a foreign donation contribution means a donation from a foreign source. So foreign source means foreign government, foreign entity, foreign company, foreign NGO, foreign government, foreign trust, foreign trade union, foreign anything. We are receiving ACS, any article, currency, security. So if we have received any article, goods, any currency, money is also movable property, and security, any shares from a foreign source, it is a foreign contribution. Sir, what is foreign hospitality? Foreign hospitality is a service. Sir, service, what kind of service? For example, service of your medical treatment, service of your staying, lodgement, uh, for your travel. So basically, it is again a donation from a foreign source where they are paying for someone's cost of travel, for boarding, that is stay, etc., transportation or medical treatment. Simple, done. Okay, and foreign source means what? Foreign source means foreign company, foreign entity, foreign trust, foreign trade union, foreign society, foreign citizen. Now we look at the sections. Okay, now what are the key sections here? The first one is section number 3 and 4 are the most important. So section 3 is basically prohibition of foreign contribution. Then section 4 says when it is allowed, prohibition, persons to whom section 3 does not apply. Then comes foreign hospitality, section 6. So these 3 sections I want you to remember: 3, 4 and 6. So 3, 4 and 6. Let's see. Now for prohibition of foreign contribution, section 3. Sir, what is section 3? So I told you that sometimes we regulate, that is we might permit, and in some cases, that is given in section 3, acceptance of foreign contribution is prohibited. So imagine giving it to someone who is a politician, giving it to a judge, giving it to a member of parliament. So all this, giving it to news house. So this seems that it is going to affect the sovereignty, integrity of India, and that is why government has prohibited foreign contribution to be accepted by any person who is standing up for election, any editor, any newspaper, any public servant, any member of legislature, political party, okay, public servant, any audio visual or any cartoonist, etc. Okay. Now section 3 subsection 2. Now what does 3 subsection 2 talk about? It talks about indirect transfer. What does it talk about? It talks about indirect transfer. So section 3 subsection 1 is directly saying that you should not give it to all these people. So I say one thing, what I'll do is I will take it in the name of someone else and then that person will give it to me. Allowed? So indirect transfers to persons mentioned in section 3 subsection 1 is also prohibited. Means no person residing in India shall accept any foreign contribution on behalf of a political party. Simple, political party directly you cannot give, so indirectly also you cannot give. Okay, similarly for the other stuff is also indirectly we are taking any currency to give it to a politician or any other any Indian. So this is no person resident in India and this is no citizen resident outside India. So no Indian nor any foreigner shall take any contribution to give on behalf of a political party. Okay, so shall not to deliver it such to political party or same thing means no Indian or foreigner should take it to give it to any political. They could have simply said no person should take it. Now section 3 subsection 3, same thing only, that no person receiving any currency from any foreign source shall deliver such foreign currency to any person other than for whom it was received. For example, what are they saying? That if there was a foreign source, they have given it to maybe a IIT, Indian Institute of Technology, okay, to give it to Mr. Arun. So they want to give it to Arun. Arun is a talented person, he has achieved. Now what did they do? This person received foreign donation. they did not give it to the person intended, instead they gave it to someone else. So can they give it to someone else? Answer is no, this is also prohibited. So basically taking the money for someone and not giving them is also prohibited. So let's see, section 3, no person receiving any currency, maybe Arun has been given a cash gift from a foreign source, shall deliver such currency to a person other than a person who it was received. So you cannot give it to a person other than to whom it was intended. Similarly, so section 3 subsection 1 says who are not allowed. Subsection 2, 3, 4, 2, 3 are simply saying indirect transfers are also prohibited. Now this they are saying where it is allowed. Okay, so these are all allowed transactions. These are permitted to take foreign contribution. So section 4 talks about transactions which are permitted, persons to whom section 3 does not apply. So for example, if I am giving it in the ordinary course of business, someone has my employees there. Okay, so Google is giving salary to its employees. Is it a donation? They say no. Agent for goods, cost of goods, they say no, it's a business transaction. It's not a donation. So that they have covered. If a foreign source is giving a salary, any payment in the course of trade, any agent, okay, so all of this is allowed because it's in the course of business. In the ordinary, any remittance received in the ordinary course of business, that is also allowed. Then one they have said is scholarship. So if they have Harvard wants to honor a person here scholarship, that is also allowed. And one thing they said, a gift within the limit specified by government is also allowed. So section 4 is basically when foreign contribution is permitted, allowed, simple. Okay, when any person has received foreign contribution, intimation of receipt of foreign contribution is made in form FC1. Okay, in form FC1 you have to write and give that I have received foreign contribution. Now we see section 5. So section 5 is not that important, directly section 6, because foreign contribution is over. Declaration of an organization of a political nature. The central government may, with regards to the activities of an organization, the ideology, with the programs of that organization, with the activities of the political party, okay, might specify that such organization is a organization of political nature. So central government may, looking at the activities of a organization, ideologies, program, association with the activities of any political party. So for example, there is a NGO, and this NGO actually feels that they are really trying to come to help a political party. So though it is an NGO, but from the operations, from the ideologies, from this, they find that it is a very big connection with the political party. So then they can declare this NGO also is deemed to be a political party. So if it is a political party, they also cannot receive foreign contribution. So any NGO can be declared as a organization of political nature. Simple. Now we come to section number 6. So what is section number 6? Just as we did for foreign contribution, which was with respect to goods, this is section 6. So just remember section 3. How do you remember? Section 3 and section 6. Section 3 is foreign contribution. Okay, so this is foreign contribution, and section 6 is about foreign hospitality. So similarly, the same people are not allowed to take foreign hospitality. Only one exception is given, that in case of illness, sudden illness, where a judge has gone abroad, or any other member of parliament, what they've given all the list, they've gone abroad and sudden illness is there, so they can't come to take approval now. So that time you can give the foreign hospitality, that is medical treatment can be given, provided that moment they are fine, they have to immediately inform the government that listen, I had gone abroad, I got a heart attack, and then this country or whatever helped and paid for my medical expenses. So let's see. Restriction. That similarly, section 6 restricts the acceptance of foreign hospitality except with the prior permission of central government. So central government's permission is needed. So therefore, all those persons, public servant, cannot accept without the permission of central government. However, it is not necessary to obtain any such permission for any medical aid on account of sudden illness contracted during a visit outside India. Okay, but they shall within 1 month from the date of receipt of such hospitality intimate it to the central government. So within 1 month you have to go ahead and inform the central government. Clear? Done. Then comes prohibition to transfer the foreign contribution to other person. Common sense. If I have taken the money, if the money has been approved for Mr. X, this money cannot be given to anyone else. Okay. So provide that a person who is registered and granted certificate and receives any foreign contribution shall not transfer such contribution to any other person. So normally NGOs get registered, get a certificate and regularly keep getting foreign donation. So if any person has been registered and got a certificate and receives foreign contribution, he shall not transfer contribution to any other person because he is registered, they are only entitled. Okay. So FC1 we had saw it was for when you receive foreign contribution. Now foreign hospitality, the application for seeking approval is given in FC2. FC1 is foreign contribution, FC2 is foreign hospitality. It is for approval, taking approval of the central government. Now comes section number 8. Very, very simple. This they are talking of administrative purpose, how much money can be used, and the answer is not exceeding 20%. So it will be max 20%. Sir, what is it? Let me explain. So when we receive, let's say we have normally what happens is NGOs which are very clear that they have a very social purpose, they themselves get registered. Okay, so let's say there is Harvard or there is some Bill Gates Foundation. There is Bill Gates Foundation. So they as it is donate always to NGOs. So let's say this NGO, in order to get regular time, every time they don't have to take approval, so they get registered with central government. So they get a registration certificate to receive donations. Simple. So they will keep getting on regular basis. Now what are they saying in this point? That imagine if Harvard has given 100 lakhs. How much they have given? 100 lakhs to the NGO. Now NGO is saying that for administrative purposes, for managing, renting, employees, etc., we are spending XYZ amount. So government said you can spend max administrative purposes 20% for day-to-day expenses, salary payments, rent, electricity, all that max you can pay is 20%. That means minimum 80% has to go for beneficiaries, for whoever it is. So minimum 80% will definitely go, because only administrative and day-to-day expenses max you can use is 20%. Clear? So keep a tab of that. Okay. That, what do they say? That every person who's registered and granted a certificate receives a foreign contribution shall use that foreign contribution for the purpose given and shall not spend, defray, that is spend or give out more than 20% of the administrative expenses. Okay, if they are doing more, then they require central government approval. This is there through an amendment. Earlier the limit was different. Now section number 9 says power of central government to prohibit receive of foreign contribution. Now pay attention. Section 9 deals, so whichever is important, I'll stress on that. All this is just reading and moving ahead. Okay, so this talks about central government has been empowered to prohibit, give prior approval, and furnish information. So let's mark it. So prohibit prior permission and furnish information. With respect to foreign contribution, so central government is empowered to, what is the power of the central government? Central government is empowered to prohibit, tell you to furnish information, and tell you that in this you require permission for foreign contribution. Same 3 points they have said for foreign hospitality, that they can prohibit you, tell you to take prior permission, and tell you to furnish information. Now, so 6 points are done. First 3 is of foreign contribution, the other 3 is of foreign hospitality. Done. And obviously, while allowing central government giving a license to anyone to accept foreign contribution or hospitality, they will look that that donation or such act does not affect the sovereignty, integrity, public interest, elections, friendly relations, or does not affect any religious or social groups. Finish. Let's see importance of and finish it. Okay. So registration is very simple, that normally any, as I give you an example, any NGO like CRY, or there is tell me names of few NGOs. I know CRY, I know Keto I've just recently so Keto is there. It is also a donation, it's a crowdfunding platform. So they can set up a Section 8 company. Now they can apply to central government and listen, we have a definite, we are surely a cultural, economic, religious, social group, and they can get license and obtain certificate. Finish. Central government will look that it's not affecting anything, and then they will grant the certificate. Grant of certificate can be given. Now, moment they grant the certificate, remember this came in Section 12 amendment, that they will tell every person making an application to make a FCRA account. Now pay attention. What are they saying? That they will tell you, let's say this is the NGO. NGO wants to get registration certificate to receive regular foreign hospitality and foreign contribution. So they apply. Now when they apply, they will have to open, and let's say the certificate is granted. Certificate granted. So they become happy. Now government is saying one thing, that you have to open a separate account. Government is saying that you open a separate account called as FCRA account, Foreign Contribution Regulation Act account. You make that account, and it should be made mandatorily with SBI, any branch of SBI, and all donations should come through one account, one branch only. Means you have to designate that this is the account where all the foreign contributions will come, and only foreign donations will come here. It cannot be mixed with domestic donations. So a dedicated account will be made. Okay, and from here it can go to multiple places, that is fine. But initial inward remittance will come only in one account, and that too it will be a SBI branch. You have to decide which one you want. And then not only that, all the basic Aadhaar card will have to be given of all the office bearers. If it is any foreign national, he will have to give his passport or OCI card. So all these 3 documents and KYC basically will be done entirely. This is what they are saying. So FCRA account will be there, but before granting they will see all those things, that it is not to convert anyone, not fictitious, not communal tension, does not misuse the funds. Okay, all those things. Who can receive? Everyone, any person having a definite cultural, economic, educational things, they can receive foreign contribution. They will apply and get a certificate. And this is important. I told you Aadhaar card will have to be given. Copy of passport or overseas card has to be given. So any of these 3 documents you want, they have to give of all the office bearers, directors, KMPs. If you do not comply with the laws or violate any of the laws, it will be suspended. Cancellation can be done. Also, one of the reasons which is interesting, which they may ask, is for 2 consecutive years, if you are not doing and benefiting the society for which you have been made, or have become non-functional, 2 years you become defunct, non-operational, then also you can be cancelled. You can surrender your license if you are done and don't want to pursue it anymore. That is done. I told you, foreign contribution only till schedule bank, section 17. How many branches you can have? You may accept foreign contribution through how many accounts? Only one single account, and of which it will be FCRA account under any one of the SBI branch. Okay, no funds other than foreign contribution, domestic cannot be taken. Okay, that's it. And moment you get the funds, or every person who has been granted a certificate or given the approval shall intimate the government. So every person who's got this money will have to tell him from where he got the money, source of fund, manner of usage, and purpose for which he's got, and manner from which the contribution was received. So basically keep intimating the government also your source of income, the amount you have got, and the where you spend the money. Audit needs to be done. Books can be audited. Any person who has been granted a certificate fails to furnish anything after inspection, the central government may, if reasons to believe, they can audit your books. So if anyone who has violated anything, the government can order inspection of your books and auditing. Okay, inspection, search, seizure can be done. Yeah. Now we just come to a part of appeals. Okay, so here you have appeal can be made provisions. Appeal provisions are given. I think we are done with all the important things in the chapter. So that is it. We have completed the entire FCRA chapter covering all the important aspects. Thank you. Clear, everyone? Yes or no? Okay, great. Till now, have you all understood everything? Yes or no in the chat box? Yes, no, quickly. Jancy, thank you so much for your kind words. Means a lot. Please inform your friends, share it with your friends, and join the Dream Batch. You'll get immense value out of it. Okay. Now we begin with our next chapter. Let me start with another chapter. Which one I'm thinking? One small little chapter I'll start in 2 minutes only. I think this I'll just complete it immediately. So this is your Legal Meteorology Act. I'm starting and completing one chapter which is called as Legal Meteorology Act. Shakti, great, thank you. Okay. So we will be starting and completing your Legal Meteorology Act, the important part, and then we'll start with another important chapter. So till that, if you want, you can revise through this entire thing. Okay, you all can revise. Then we'll start off. So we take maybe a 5-minute break. I'll be back quickly because it's a very small chapter, and then after that we'll take up a good chapter. Okay. Guys, am I audible and visible? Please put in the chat box. So I can quickly knock off more and more chapters. The more excited and the more energy I'll show, it gives me equal double energy. Okay. So again, I'll be completing this chapter and everything that has come in the past exam question, including the all important aspects also. Okay. Quickly in the chat box, can we start? GTG in the chat box. Yuvashri, great. Jansi, great to have you. Let's start. Hi, so we'll be starting with a chapter called as Legal Meteorology Act 2009. Now, what is the meaning of the term legal? Legal means a law and meteorology is the study of weights and measures. So, what does meteorology mean? Meteorology means a study of weights and measures. So all of this is weights. When you go to the gym, it's a weight. When there is when you go to take your goods, okay, they have this weighing scale that is coming under this act. Okay, all of these things I think you must have seen in the market when you go to buy vegetables, etc. So that's here there is a law with respect to this, like how this should be there, because this hits every single one of us on a daily basis, because we buy on basis of weights. Even if you buy a packet product, in the packet product, they always mandatorily, every manufacturer has to put the weights. Okay, so it is due to this act. Now before this act there was something called as the SWAMA Act, the Standards, Weights and Measures Act was there 1985. This got repealed and instead we have the Legal Meteorology Act. Okay, Legal Meteorology Act was passed 2009. So what is the meaning of the term? First, let's see the object of the act. So the object of the act is, it seems it's pretty small, but it impacts every one of us. What if we are buying something which is given at a wrong weight, or we are thinking we are buying 1 kilo, but in reality it is less, or the weight is not given? So how will you do the measurement? How will you do the comparison which product I should buy? And how would you ensure accuracy of the weight? So this act ensures that all weights should be accurate, okay, and correctness of the measurement is ensured. So legal meteorology, as I told you, the meaning of the term legal meteorology is a part that study of weights and measures. It deals with the units of measurement. So weight could also mean, if you are buying it's a liquid, then in liters. If it is area, then in square feet. If it is temperature, then it will be in degrees. So all those units of measurement should be standard. So there has to be standards, weights used, measurement used, units used. Now why is standard weights and measurement units used? So it helps in comparison. For example, if I pick up a chips packet and I see it is 5 grams, but if in the other side it shows that it is 8 pounds, I won't be able to compare and make my decision making. So that is important. So weights and measures are important element of the economy. It promotes, this act promotes fair trade, competition, efficiency, leading to the overall growth of the economy. As an Indian consumer, they are purchasing foods, clothes, liquids, etc. Okay, on a daily basis. We trust the businesses that they are measuring their products as per international best practices. To ensure that all the weights, measures, measuring techniques are as per international best practices, the Legal Meteorology Act was formed. Okay, all manufacturers, okay, dealing in packaged products have to be registered under the act. Now, the weights and measures. So I told you that only internationally recognized units of measurements can be used. So section 4 and 5 deals with that for length it should be in meter. If you see all of this, this is how the goods are being shown. mass will be in kilograms, kgs, time will be shown in seconds. So if you have a laptop or they are seeing the processor, it is shown in seconds. Okay, electric meters, when you're buying any kind of bulb, etc., shown in amperes. Okay, luminous intensity, so how luminous a particular product or color is, that is shown in candela. So these are the international systems units which we use. Now we come to important part, which is section number 17 and 18. Okay, so section 17 and 18 is very important. What does it say? That every manufacturer, so mainly it is for the manufacturers, okay, every manufacturer, repairer, etc., shall maintain records and registers. So first thing is, every manufacturer has to maintain records, and it shall be produced at the time of inspection. So manufacturers, so once there was a case where the company, there was a raid on that company, and they told that show us where the products are. They were checking whether the labels were correct, whether the weight was shown, whether certain information display panel is there, principal display panel, did it show the expiry date. So all those basics has to be shown. The ingredients are shown or no. So this comes under that act, that all that information should be preserved, should be shown. An obligation to manufacture for sale any pre-packaged commodity should be in standard quantities. Now if you go to see, any commodity has to be in standard quantities. So even if you go to see, for comparison purpose, biscuits will be 10 grams. So all the biscuits will be in 10 grams. So you can compare what is the pricing. So they have certain standards in that. You can't just make a product of 4.7 grams. So that is not allowed. They have told that this is the standard, that is how it is there. So it's easier for comparison and calculation. So we saw section 17 and 18, you should maintain the records. And even pre-packaged commodities, means the product which will be put into the package, that also should be there in standard quantities. Now inspection, the director general, okay, controller or any other legal metrology officer can inspect any premise if he wants, okay, and if he has reasons to believe that any offense has been committed. So inspection rights are there. If they find that you've done something wrong, they can forfeit it also. They can forfeit anything. So section 15, 16, 17, 18. Okay, this is there. So what is 15? That the officer, legal metrology officer, will have a right to inspect any premise, place or any goods to see whether the act and the weights and measures are used according to the act or not. If he finds anything in contravention, he can forfeit it. And it is a duty of every manufacturer to maintain any records and produce the records when at the time of inspection. 18 says that even pre-packaged commodities has to be in standard quantities only. Now if government has taken action against you, you always have a right under section 48 to apply for compounding of offences. What do you mean by compounding of offences? It means to settlement of the matter by paying, okay, certain settlement charges. After that, case will not be proceeded with, or if the case has already been started, then it will be dismissed. Okay, and in compounding, one very important line is they will tell you to pay some amount. Now how much money to pay? They are saying that the fine amount shall, the maximum amount of compounding charge or the settlement amount that they can take should not exceed the maximum amount of fine which is imposed for the offense. Common sense. If imagine the maximum fine for the offense is 1 lakh, can they tell me to pay compounding charges of 2 lakhs? They'll say no, settlement means somewhere in middle. Max we can charge is the fine amount, maximum fine amount. Beyond that we can't charge, because then I'll say I'll rather pay the fine only. What compounding you're doing? So compounding means a settlement. So if the fine amount, if you break the signal and the fine is 10,000 rupees. Okay, so the maximum the police can ask you is 10,000. And for settlement, obviously you have to pay something less only. Now the Legal Metrology Act has to be read with the rules. That is, the Legal Meteorology Packaged Commodities Rules 2011. It speaks about something called as a principal display panel. It talks about something called as a principal display panel. Sir, what is a principal display panel? A principal display panel is basically where all the information of the product will be given. Okay, it will be a certain surface area on the product or the package where certain nutritional information about the product, its ingredients, its constituents, its whether it is veg, non-veg, its daily value and its weight will be mentioned. So once they had asked in the exam what is a principal display panel. So as per the rules, a principal display panel is the total surface area on a package where information about the product is given. Okay, all information are grouped together and given at one place. Now interestingly, what did they do? They said that you shouldn't end up fooling the government where you put in very small letters. So they have also said that it specifies the height of the letters, that it should not be less than 1 mm, and also the width of the letter should not be less than 1/3 of the height. So they've also told that the height and the width, how much it should be. So you cannot have really small little tiny little ingredients mentioned. So minimum 1 mm height and the width will be at least 1/3 of the height. So decent enough space. Now sir, what declaration has to be there in the principal display panel? So when you read rule number 6, it says that every package shall have the name and the address of the manufacturer, the generic names. If it is medicine, they write what is the generic name, the net quantity of the goods, the expiry date, the manufacturing date, the MRP. Okay, MRP is given, etc. And another important matter is that if the consumer has a complaint, where they can make the complaint. Now they've told pre-packaged commodity. So from the name itself, it is inside the package or outside the package. So it is pre-packaged, means it is not yet put in the package, but it will be put within the package. So even pre-packaged commodities we saw has to be in standard quantities. Then only the final product will be of that quantity, right? So pre-packaged commodities is a commodity which will be placed in the package. Common sense. Declaration on the pre-packaged commodity also has to be there. Okay. So no, section number 18. No person shall manufacture, pack, sell, import, distribute any pre-packaged commodity unless such package is in standard quantities. I told you it has to be in proper quantities. Any advertisement mentioning the retail price of the pre-packaged commodity shall contain a declaration that the net quantity or the number of the commodities contained in the package. Any advertisement mentioning the MRP of the pre-packaged commodity shall contain a declaration as to the quantity and the number of commodity contained in that package. So normally they will mention that if I'm selling it to a manufacturer, so I'll tell that in this 5 of this will make up this much weight. So just remember that any advertisement that we are doing for sale of the pre-package, someone is just buying this pre-package, will do their own packaging and sell. So you have to give the quantity and pricing also. Now retail price and wholesale price. Retail price means the retail package means the package will be sold to consumers. Directly. Retail, we buy from retailers, and wholesalers don't sell to retailers or to consumers, they sell it to retailers. Retailers, not to consumers. Now wholesale. So is a sale to intermediary and he is not intended the ultimate consumer. Now there is a concept called as calibration. So calibration is a science of how to fix the marks on certain metals. So basically if you go to see a metal is there, after fixing the mark, it should be of 5 kilos. So how much precision and proper science will go in fixing the mark, and then post that it should weigh as much as being told. So this is there, so they should tell. So all the operations necessary for determining how much error we can make max, to determine the properties of the weights and measures, and it includes the science of fixing these marks, scale marks, etc. onto this. So calibration is a process, is all those operations which are necessary to affix these marks and figure out the maintain the world. Then comes to counterfeit. Counterfeit means fake or knockout goods. Knockout goods are those goods which are made to resemble that of another person. So when someone is selling a shoes such as Puma, okay, and this O is also made pretty like this, okay. So it is trying to resemble another brand which is Puma. So it is likely to cause a deception in the minds of the people. That is why it is called as counterfeit goods. Then we have something which I have asked in the exam also, International Organization of Legal Metrology. So basically this is an international organization. So it is a multi-governmental body. So from the name itself, international organization means it is a intergovernmental body. Okay. And of legal metrology. So this multi-government body is with respect to making global standards, global recommendation for weights and measures. So they want to promote that the whole world should have the best standards, practices and legal metrology procedures. So they will develop certain model regulations and recommend certain practices which are to be followed, and internationally all the countries they agree, then they will pass the particular recommendation or regulations. Now more and more countries want to become member of this, because if they are having what the world is having, then it becomes easier to be sold and you will be able to meet the international best practices and specification. Any company which has met it, they will issue a certificate. A system of OM certification is given to manufacturers indicating that the instrument or the type or the pattern complies to the relevant recommendation. So just like a ISO mark is there, here you could have a OIML certificate. OIML means International Organization of Legal Metrology approved weights and measures are there. Okay. With this we have completed the entire chapter. Thank you. Clear guys? So one more chapter knocked off. I want everyone to give a smiley in the face in the chat box. A small little smile in the face in the chat box. Or you can send some hearts also. It just feels good. Okay. Now I'll be starting with another important chapter and I will complete it. But just want you all to be a little responsive in the chat box. What does forfeiting mean? So forfeit means to take away. Forfeiting means to forcefully take the goods. So for example, if you have done a contravention, then they can forfeit your goods and take it. Clear? That's it. Now I plan to start with another chapter. Most likely I want to complete multiple chapters I can complete, but still let me complete SEZ Act. Okay, so another act I can complete quickly, that is SEZ Act. Okay. What about others? Yes or no? So now I'll start and complete SEZ Act. Okay. Special Economic Zone. That is also one of your chapters. It's your lesson number 6. That is there. Okay. Lesson number 6. Okay, so I will be starting and completing lesson number 6 now, which is your special economic. Okay, so we take a 5-minute break, then we complete it. Okay. What are the other important chapters? Okay, great. So Arun is asking that does scanner is very much important. So Arun, just referring the scanner even for half an hour will let you know what are the questions they are asking, what is the model answers, because sometimes question might not be direct, so they might be, so you will get an idea of how it is there. Okay. So Jansi, I'll be going on trying to cover as many chapters as I can. Okay. So till how much ever I can, I will try completing knocking off chapters. So can't tell you the limit. I'll try my level best to cover as much as possible. So we'll take a 10-minute break and then we come back and we complete this chapter. Hi guys, am I audible to all of you all? Okay. Quickly in the chat box, am I audible, visible? Yes or no? So I can quickly start and complete this chapter. Just write audible, visible in the chat box. So I'll quickly know and I'll start and complete the chapter. Or GTG in the chat box. Okay. Feroz, nice. What about others? So I'm going to cover and knock off another chapter. Shakti, Jansi. Okay, nice. Nice name. Let's begin. Hi. So we'll be starting with a chapter called as Special Economic Zones. Let's understand the concept of SEZ real quick. What happens, let's say if this is entirely India. We know that entire India is not developed. There are certain undeveloped regions. So what the government does, if let's say this is an undeveloped region, what it is, it's not yet developed. So it is undeveloped. So government says that let me do something. They will declare this area to be SEZ. They will declare this area to be SEZ. Moment it will be SEZ, it will become a tax-free zone. So any business coming in, no amount of tax will be levied on them. So mostly tax would not be levied at all, okay, on them, or maybe they can have some terms and conditions for maybe a sunset clause that you will not no tax for 10 years, etc. Then what happens? Moment they say no tax, many businesses love and they set up themselves here. Moment they set up here, then automatically the roads will become better. There will be a hospital, there will be schools, etc. Okay, so then it's a win-win situation for the business because they will get tax-free, and it is good for the government point of view also because they develop a undeveloped region. Okay, it creates employment opportunities, etc. Okay. So what is a SEZ? SEZ is actually a scheme that you come develop this region, we will not levy tax on you. Okay. So government uses various methods such as setting up something as a SEZ and attracts the industrialist. With this, these are considered, SEZ are considered to be growth engines. That means it will boost the entire area, and if you buy property in a SEZ, before it is declared as an SEZ, you will make double, triple the money. So before Talegaon, there was a place. Before Talegaon was declared to be an SEZ, a lot of buzz went in the area that this area might become a SEZ, and some people bought the land. Moment they bought the land and the government declared it to be SEZ, now they know that this land cost will increase because in 10 years, 5 years, the entire area will look different altogether. Okay, from there obviously businesses will do sales. They will not only sell in India, they will also sell out of India and do exports and generate foreign currency. So it's a very simple scheme that the government has made. What is the object of the act? The object of the act is first of all develop infrastructure, generate jobs, generate exports, okay, make new roads, expedite the grant provision. So anyone comes, we feel we should quickly give them a single window clearance. Means you just come here, you get one license, directly start operating multiple places. You don't have to go to open various this that, because government is not, they want you to come here. So they will give you single window clearances. Okay. Now let's get into the act and understand. It starts with establishment of SEZ. Now my question to you is, does the government declare an area to be SEZ? Suo moto, or a person will apply that, I will tell the government that listen, I am ready to develop this area. You declare it to be SEZ. So identify an area as SEZ, as a special economic zone, that this area is very, very good, it's undeveloped, it is good for growth engine, we can boost it up. So this will be done by the government. Government will identify and tell, or it will be done by the developer. Let's say developer here, I mean the company. So company is saying that I will come and develop this area. What do you think? The government will do or the developer will do? So the answer is both can do. Anyone can come and say. So government themselves, they can identify an area, declare it to be SEZ, or a developer can write an application to the government and the government will look whether this area should be declared as an SEZ or no. Okay. So it could come from any person. So they say that section 3 says establishment of SEZ provides that the central government, state government or any other person may establish a SEZ. Any person who intends to set up an SEZ may, after identifying the area. So anyone, even if I am interested, I will identify the area, make a proposal with the state government and for setting up as a SEZ. And then the government will forward it to the board of approval, okay, to approve whether we should accept this area as a SEZ or no. Okay. The state government intends to set it up, may, after identifying the area, forward it to the board of approval, set it up. Central government has been identified to set up and notify the SEZ without consulting state government, without referring to the proposal to the board. So what it is, very simple. We saw this. So any of the parties are interested, they can go, they can develop, they can ask for declaration as a SEZ. Now what happens if the state government has identified a region that they should declare it as SEZ, they will have to go to board of approval. This board of approval will decide whether area should be declared as SEZ or not. So what happened? The board of approval, it's an authority whose job is to approve whether this area should be declared as SEZ or no. Because if we just declare it and we have loss of taxes, so the government says that we need to have an authority to think over that should this area be declared as SEZ. So board of approval is there. Whereas central government wants to go, they don't have to take anyone's permission. They can directly go and declare a thing as SEZ. Okay. Who sets up SEZ? As I told you. Who sets up SEZ? So any government agency person can set up a SEZ, make an application to set up an SEZ. So section 3 is done. Now we come to section number 4. Establishment, approval and authorization to operate SEZ. Now here earlier we had seen mostly they had spoken that the government is declaring SEZ. Now here what happens? First, if the developer has decided, developer means the company will write that I am ready to develop this region, declare it to be SEZ. So here the developer submits his letter, okay, a letter of approval with the exact area identified which he wants to be declared as a SEZ. Okay, this will then be scrutinized. Guidelines for considering and notifying an area to be SEZ. Now, one very important thing is what the government will look before to declare a SEZ or no. So they will look at basic stuff. Section 5 says that you will look, the central government while notifying any area will see how much economic activity it can generate, how much promotion of export will it bring, how much employment can it bring in, how much development of infrastructure is needed, and whether it is in line with the sovereignty, security and integrity of the country. Here we will look that is that area required to be declared as SEZ, what all benefits will we get, employment, infrastructure, exports, employment, and whether our integrity of India will be protected or no. Okay. Now the biggest reason, just tell me one reason why someone would be interested to go into and set up an SEZ. Obviously it is no tax. So section 7 exempts all goods and services that have been imported in, that come or go out of SEZ area. Now I told you we had earlier also seen board of approval. So section 8 empowers the central government to by notification the board of approval within 15 days of commencement of the act. So moment the act was passed, within 15 days board of approval was there. Now what is the job of board of approval? Section 7, section 9. So again, if I'm just thinking board of approval, so they approve whether an area should be declared as SEZ or no. So the duty to promote an orderly development of SEZs. Let's see the roles. Okay, the power and functions of the board. So what is the job of board of approval? Whether they should approve or reject proposals for establishment of SEZ. So should we declare this to be SEZ or no? Is the job of board of approval. Don't forget, there are 2-3 authorities that will come. Students normally get confused. So remember, board of approval approves or rejects a proposal to establish as a SEZ. Granting approval of authorized operations. So what operations can be done in SEZ, that will be decided. Granting of approval to developers for foreign collaboration. So maybe in that area you want an SEZ, you and a foreigner wants to come and set up a business there. So they will approve that. Granting of approval or rejecting the providing infrastructure facilities. So what all facilities will you provide? Will the developer give? So the government will tell the developer only, now you have to make a school, you have to make a college, you have to make a hospital, you have to make latrines, you have to make everything. So what all, before granting approval, we will see that what infrastructure you are going to develop. Granting a license to industrial undertaking, whether we should give it. Suspension. So now obviously includes, like giving license also includes cancelling it or suspending it. Okay, and disposing of appeals that come to it. Very simple. Okay. Now we see suspension of letter of approval and transfer of SEZ in certain cases. Letter of approval is being suspended. So empowers the board to suspend a letter of approval granted to the developer for a period not exceeding 1 year and appoint an administrator to discharge the function of the developer. Common sense, the developer is acting smart, developer is violating something, then the board of approval, the board, okay, can suspend the license granted, the permission granted for a period maximum. It's a suspension, so for not exceeding 1 year, and appoint someone in his place to continue the functions. So now when will suspension be ordered? By the board. So should we make a happy smiley or a sad smiley here? So should we make a happy or sad smiley? What is happening is there is a suspension. Okay, so first is the 1, 2, 3, 4. Under these 4 circumstances, they will suspend. So the developer is unable to discharge the function. So the developer, the business is not able to discharge his functions or duties. The developer has continuously defaulted with any of the directions given. He has violated the terms and conditions of the approval letter, or the financial position of the developer is such that he is unable to fulfill or discharge his duties. So these are the reasons where they can suspend his letter. Now first authority is over. What we did was the development board of approval. Now we see someone called, since board of approval is a panel of people like BOD. Now development commissioner is a person who works closely one-to-one with the developer. For example, let's say board, here you have the board of approval. So they will approve whether to set up or not to set up SEZ. This is their main role. Okay, this is their main role. Please note it down. Main role. After they have approved, okay, let's say they have approved this region to be a SEZ. Let's say they have declared this region to be SEZ. Then they will appoint a development commissioner who will work and observe and monitor and guide a developer. So developer is a business or the company. So the development commissioner will ask the developer, look at his trends, see whether he's doing, guide him, do sanctions, etc. So this is the second authority. Let's see. So commissioner is like a police who will be there in that SEZ. Okay. So section 11 empowers the central government to appoint development commissioner for one or more SEZs. Functions. The function of the development commissioner requires a development commissioner to take charge to discharge the functions of a speedy development of SEZ. So his job is to see that there is a speedy development of SEZs. Now these are the functions. You can mark it as important. So I told you he works closely with the developers, with the entrepreneurs, or we can say the developer. He will take measures how promotion will be done. He will help coordination with the government. He will monitor the performance. Okay, he will see whether the party is discharging the functions assigned with him or any other thing that has been delegated. Clear? Now we see the next thing is constitution of approval committee. Now let's see what is approval committee. So we are done with one is board of approval. The other one was development commissioner, and now the third one is coming as approval committee. Okay. Now listen to what is approval committee. For every single SEZ, there will be for if there are 100 SEZs, 100 approval committee will be there. True or false? Let's see. Answer is true. Pay attention. That section 13 empowers the central government to constitute a committee, a approval committee for every SEZ, called as the approval committee. This is the daily things, what will come in, what will go out. From SEZ you want to take it outside, what is being imported, what is being exported. So every activity will require approval of the approval committee. Simple. So once everything as SEZ has been set up, then we know that this is the SEZ. Now we'll have an approval committee. For certain things you will require approval of this committee. Let's see. Powers and functions of the approval committee is given in section 14 to approve certain goods from DTA to come into SEZ. So what is it? Let me explain. So let's say if this is India, this has been declared as a SEZ. Okay. Then everything else is a domestic tariff area, means the domestic rates and tax will apply. So if some goods are from the DTA are going into SEZ, or some goods are coming from SEZ into DTA, then the approval committee will approve such transactions. If goods are going outside India, exports, or goods from outside are coming into the SEZ, so it's like an import. So this also you will require approval committee permission. Clear? Simple. It's about transaction, goods flowing in on a daily basis. Okay, who is the service provider, where the warehousing will be done of the goods, etc. Okay, so approve the providing of services from person outside India, monitor the utilization of the warehousing. Okay, so the warehousing will be seen, modify, approve setting up of manufacturing units, allow the foreign collaboration for an FDI. Okay, monitor and supervise the compliance and perform such other duties as may be given. So the main work is to see where the goods flow. So they keep studying the goods and the services from outside India into India, from DTA into SEZ, SEZ into DTA, warehousing of the goods, setting up manufacturing units, etc., which will be there. Okay, now we see the next one, that is setup of unit. So section 15 entitles any person who intends to set up a unit to submit a proposal to the development commissioner. So we saw that if someone is interested to set up a SEZ, he will give in writing his proposal to the commissioner. That commissioner will give it to the board of approval, will forward it before the approval committee. The approval committee will approve it. In case of modification, the approval committee has put under the obligation to give an opportunity being heard. Okay, any person aggrieved by an order of approval committee will make an appeal to board of approval. The development commissioner may, after the approval and grant of the letter of approval, set up a unit. So they are saying first you go to development commissioner, he goes to approval committee, and then we have a board of approval. That also flow can be done if it is from a person. Okay, if any entrepreneur wants to go, he can go this line. Cancellation, obviously, before cancellation, opportunity being heard will be given. It is generally if you have entrepreneur has or contravened any of the provisions. Setting up of operations of offshore banking unit. Okay, now what is an offshore banking unit? Right, let's read. So offshore banking unit is a bank located in SEZ. Okay, and let's see, one more is connected. Okay, is IFSC. You know the meaning of International Financial Service Center. The central government has approved the setting of an international IFSC in a SEZ. May approve only one IFSC in a SEZ. They will frame the guidelines. Okay, and all the operations that will be done. So let me explain that. So what is a IFSC? Let me come to it directly. So IFSC is basically any region will be declared by the government as first SEZ. It will be declared as a SEZ. Then it will be declared as an International Financial Service Center. That means it will not cater to Indians. The main job, the main primary thing is to cater to international crowd. So maybe an international bank can be set up here and they will cater to international clients only. So not Indian. So we set up a separate region altogether like a gift city. Once you're set up there, then it will be set up as per international standards. Just like your Dubai IFSC is there, or you see a Shanghai IFSC or your New York IFSC. Okay, the purpose is just to make it completely different from the country with the best infrastructure, best equipment, best Wi-Fi, and as per international practices. Now we can't develop whole of India like that, but at least one region we can do it. So and we say that it is a SEZ, so it is tax free. So we are not only attracting people from India, all over the world, the countries from all over the countries, from all over the world, the countries will come up, companies will come and set up here. It's an SEZ for abroad. So offshore banking unit means what? It is set up in an SEZ and it provides services to offshore clients. Simple. IFSC has the same thing. If you are unhappy, you can go and appeal to the High Court also within a period of 60 days. Okay, you can appeal to the High Court within 60 days. Now, identity cards will be given to each. So, identity cards section says that every person who is either employed or residing in the SEZ must be provided by an identity card by the Development Commissioner. So, in the SEZ, who is entering, who is not, how many employees are there, all will get an identity card. Now, if there is a conflict between SEZ and other acts, if there is a conflict between SEZ Act and any other act, then the SEZ Act will prevail because it has a overriding effect over all other laws, etc. The section 51 says that the act has overriding effect over any other law. Okay. With this, we have completed the entire chapter. Thank you. Okay. Guys, we are done with this chapter also. Okay. Yes. Great. So now we are done with this particular chapter. I'm planning to take one more chapter and complete that as well. Okay. So obviously whatever I'm covering, then you don't need to read anything more. Okay. Or you can see just the past exam questions for it. It's more than enough. Now I'm just thinking to take up one more chapter. I'll take a Okay, so we'll be starting with Money Laundering Act. Okay, so we'll be starting with Money Laundering Act. Till here, everything clear? If it is clear, just put it in the chat box, clear. Then I'll begin with the next chapter quickly. Quick way, everyone, just give me 2 minutes. I will come back and complete this chapter. In the chat box, just write clear, and then we start and we complete this chapter. Okay, write clear in the chat box. Thank you so much. Everybody sending the hearts. Feels really good. Firoz, great. Neetu, great. Okay. So we will be completing this chapter. Give me 2 minutes. We'll take just a breather and come back and complete this chapter. Okay. Shakti, great. So don't go anywhere. In 5 minutes, I will come and complete this entire chapter. Hi guys, am I audible and visible to you all? Okay, so Arun has asked a question. Till that you all can tell me that does we need to memorize all the penal provisions? No, you don't need to memorize the penal provisions at all. Okay, does except for Competition Act, that is easy. Okay, you can write. Does writing facts of the case in each of the marks, if we don't know the answer, we can write facts of the case alone. No, you have to write facts of the case along with other things is fine. Only facts of the case, obviously 0 marks. You have to write something, some law, something like that, at least to build something. Otherwise, you're writing the same question. Just for writing the question, you think you'll get marks. Okay, chalo, we'll be starting. GTG in the chat box quickly. GTG in the chat box. GTG, so we quickly start and complete this chapter. Everyone, GTG in the chat box. Great. Chalo, we'll be starting. Yeah. Hi. So we'll be starting with the chapter called as Prevention of Money Laundering. Now, what is money laundering? Money laundering is a process of converting your black money into white money, converting your illegal money into legal money, converting your illicit funds into appearing to be legal funds. Okay, so it is a process of disguising the origins, the criminal origins. So what happens, criminals, when they generate proceeds from terrorism, selling of illegal arms, ammunition, drugs, the prostitution rings, when they get this money, they can't directly buy property. So they have to first apply a process of money laundering process where they disguise or they hide the origin. And you might not come to know that from where this property is, the source of the funds. So the first, money laundering happens in 3 stages. So first, it's an exam question, and money laundering happens in how many cases? So money laundering happens in 3 stages. The very first stage is called as placement. So first stage is where the illegal funds are introduced into the financial system. Okay. So placement. So just like you have, why it's called as money laundering, it's just like a laundry system where you take dirty money, you place your dirty money, apply some processes, maybe could be hawala, could be multiple techniques. I don't want to get into that of how you can convert your black into white. And then in the end, integration means after it is converted, so your illegal money is now washed. That washing process is called as layering, and in the end you can now buy. So you see these politicians, after they do the money laundering, then they buy houses. It appears that they have done some big business, etc. Okay, so placement is introducing the funds, layering is applying complex procedures to disguise its origin, and integration is basically enjoying. It's the final steps of using the proceeds which now look legal. Okay, impact of money laundering, they had asked once. What is the impact? Obviously, what happens, the criminals will now control the entire market. So if left unchecked, it is very serious, because the criminals will keep laundering the money and start now taking influencing the politicians and other organizations. Because of laundering, if it is not stopped, the criminal activity will continue. Now, there are some global initiatives that has happened to combat money laundering. Okay, so money laundering is not only a problem of India, it is worldwide. Criminals gain illegal money and they use some processes to convert that illegal money into legal money. Now we'll see each of them. So these are all year wise. In Vienna Convention, it was the first major initiative taken by United Nations to combat, directly they don't say money laundering, but from where you can get illegal money, by selling narcotic drugs. So drug dealers used to get this money, have a lot of money, and then they have to apply some procedures before they can actually buy the properties. Otherwise, they'll be caught red-handed. Okay. So remember the word that Vienna Convention talks about drugs. Okay. They said that we should criminalize money earned from drug trafficking. Okay. Then came Council of European Convention. Now again, they said that it was in 1990. They said that we should have some common policy for money laundering, have some international cooperation for money laundering, and they have spoken about search, seizure, confiscation of proceeds of crime. So what have they spoken about? That do search, seizure, confiscation of proceeds of crime. So Council of European Convention have said that we should do search, seizure, confiscation of proceeds of crime. Simple. Okay. And to do that, we also need international cooperation. Then the next international initiative was by European Union money laundering directives. Now, what did they say? That we should criminalize money laundering, okay, and we need to maintain internal systems to prevent money laundering and identify customers and report suspicious transactions. So, what did they talk about? First thing is they wanted to make money laundering a crime. Second, they said that banks and financial institutions should maintain proper KYC and make suspicious transaction reports, so it can be detected much faster. Then came the Basel Committee. The Basel Committee said that it is mainly for banks, international banks. They should do KYC, identify their customers. Normally, banks are used to launder money, is to convert the origin of the money and make it look legal. So therefore, Basel Committee has said that the banking sector should be and set up a good KYC system. Then came securities law, okay, with respect to Securities Commission. So International Organization of Securities Commission has said that the security market, the securities and futures market, should not be used as a tool to convert their black into white. Normally, you see some of the companies are alleged that this is all black money that they are rotating and pumping up the share price. So they want that. They said that they should encourage members, that is your member countries, to take steps to combat money laundering. Now came global UN global program against money laundering. So again, United Nations Office of the Drug Control and Crime Prevention implement this program against money laundering. So they said that there should be technical cooperation between governments, because normally what do people do? They don't just use one country. They try to route it back into India through FIA, etc., and then pump in money, sourcing it to certain tax havens. Okay. So then they said that there should be technical cooperation. International community should be ready to cooperate, and commitment should be given by the various agencies. Why does money laundering have an economic, what influence does the money laundering have an economic development? I told you it has a serious impact. If left untreated, the criminals will control the system. Then comes to the most important international body, which is called as Financial Action Task Force. Now, Financial Action Task Force was established by the G Summit in Paris in 1989. So some facts: it is a intergovernmental body. So this is not a one body of any one. It's not a body of any nation. All the countries are signatories to it. Their job is to develop and promote policies that combat money laundering. Okay, it is the main policy making body. Okay, it has spearheaded the efforts to adopt and implement measures to counter the use of financial system by criminals. So we are seeing what is the Financial Action Task Force. It's an intergovernmental body to combat money laundering. It makes policies and encourages countries to implement them. The main task of Financial Action Task Force is monitor how the countries are progressing, review the money laundering techniques and laws, and promote the best practices. Okay. Now we'll see the money laundering law of India. What is the money laundering law of India? It is called as PAMLA, Prevention of Money Laundering Act 2000. Okay. So the Prevention of Money Laundering Act is to prevent money laundering and confiscation of the property involved in money laundering. Now, Section 3 is saying that if any person acquires, possesses, transfers any proceeds, okay, which are of crime, they shall be guilty of money laundering. So any person who acquires, possesses, owns, transfers any proceeds of crime, or knowingly enters into any transaction directly or indirectly, or tries to hide the proceeds of crime, is deemed of money laundering. Means anyone who deals with proceeds of crime can be guilty of money laundering. Okay. Then the punishment has been given. What is it? Now very important is attachment of the property involved. So if any person has done money laundering, then there is an investigative procedure. First, the money laundering officer or the director will give him a show cause notice, and he can provisionally attach the property for maximum 180 days. Okay. So if a director is there, director of money laundering, he feels that this person has done something wrong, he will give them a notice and attach that property, and within 30 days from attachment, file a complaint before the court. Court is called as adjudicating body. The adjudicating body, okay, will then hear the complaint and give an opportunity being heard to the parties and tell him that why this entire property should not be deemed to be money laundering and take possession by the confiscated by the central government. So on receipt of the complaint from the director, the adjudicating authority will serve at least 30 days notice upon the person, telling him to give his source of income and how he acquired this property, and evidence that why this should not be taken as proceeds of crime and should not be confiscated by the government. Then after hearing, the court can, adjudicating authority will pass the order. Section 9 says if they have decided to confiscate, it will become that of the central government, will become the owner of the property. Then obligation of banks and financial institutions and intermediaries. Okay. So section 12 to 15, okay, talks about very important obligations of banks and financial institutions. So bank and financial institutions have to maintain record. They have to any director comes, they gives them ask them information, they have to give the information to them. They have to make cash suspicion transaction reports. So this is all banking companies, and they should do KYC before onboarding a client. So every banking company, okay, shall maintain records of all the transactions. Okay, this information shall be furnished to the director when it is asked. Okay, the records are required to be maintained for a period of 10 years. Section 13 says that the director may call for additional records also if he deems fit. And if the banking company has failed to maintain the records, a fine can also be levied. Section 15 empowers the central government to prescribe the procedures of maintaining and furnishing information under the Act. Okay, then we all know KYC. Whenever you go to open your account, it is mandatory for banks under the PAMLA to ensure to have the adequate KYC and have proper KYC policy of seeing who to accept, identify, monitor the transaction, and do proper risk management. Information to be preserved. Banks are required to maintain all the necessary information with respect to the nature, amount, date of the transaction and the parties. Maintenance and preservation of the records. Banks are required to maintain information about all the transactions, should ensure that the records pertain to the identification of the customer, his address, are preserved properly, and banks should pay special attention to complex, unusual patterns in transactions. Okay, now introduction of new technologies, credit cards, debit cards, smart cards and gift cards. Okay, bank. So they're just saying that bank should be careful. Nowadays, fraud is happening in all new cases also. So bank should pay special attention to any money laundering threats that may arise from these new technologies, which is now credit cards and debit cards are from many years. Many banks are engaged in businesses of issuing a variety of electronic cards, ATMs, etc. Bank should ensure that full compliance of the KYC or anti-money laundering laws is done before we give any kind of cards or add-on cards also. Marketing of credit cards should be done through authorized agents. Okay, and they should only be given after a proper KYC is fulfilled. Now, if any bank or anyone has identified a suspicious transaction, then where they will report. So mark this as important. Okay, reporting of to the Financial Intelligence Unit of India. In terms of PAMLA rules, banks are required to report information relating to cash and suspicious transaction report. Okay, of more than 10 lakh rupees or equivalent. Okay, so if it is of more than 10 lakh rupees or equivalent, then it will be given to the Director of Financial Intelligence Unit of India. Okay, so banks will report such information relating to cash or suspicious transaction if it is greater than 10 lakh rupees. Okay, with this we have completed the entire chapter. Thank you. Clear till here, everyone? Yes or no? Till here, is it clear? Yes or no? In the chat box, quickly. Okay. Great. Okay. Okay. Neetu, great. Glad. Which is the chapter? So just looking at which next chapter we can pick up and complete. DCB is a good chapter to complete. Lesson 9. Okay. So this will be the last chapter of the day that we'll be doing. Okay, which is your okay. Let's see if we can continue. Should we complete ECB also in the chat box? Yes or no? Okay. How big is ECB? Looking at. Okay. So what we'll do, we'll wrap up here. What you can do is you can study from the dream batch. A lot of chapters are given. Okay. Ashwin, great. Nice. So Neetu, great. Fine. So that is it, guys. Today we'll wrap up here. Now you can study from the dream batch. I've given you access to the lectures also. Go ahead. I've completed a lot of chapters. Easily 50% of the chapters I've covered. 20 marks is alone competition act only. So with this, I wrap up for the day. Thank you so much, everyone. Do share it with your friends, and if you've not liked the video, please go ahead and like. And even you're watching later, you can go ahead in the comment section and tell me how you like the lectures, how it helped you also. I'll feel good to read all your kind messages. Thank you so much. Take care. Bye.